appeal in the matter of Sun Pharmaceutical Industries Limited and others, and the Secretary of State for Health and Social Care and others.
My Lords, I appear with Mr Johnson and Mr Luckhurst for the appellants. Mr Perrett's KC appears with Mr Drake for the respondents. This is my appeal against the Competition Appeal Tribunal's determination of a preliminary issue on limitation in its judgment of the 21st of June 2024. It's common ground that this claim was time barred under the Limitation Act 1980 when it was issued in the High Court on the 19th of June 2019. The Tribunal has in essence held that by transferring the claim by consent to the High Court, from the High Court to the Competition Appeal Tribunal, and then by finding a claim form instead of particulars of claim, the claimants made a claim within the CAT rules, and that, according to the Tribunal, fortuitously resurrected their time-barred claim. And that is despite the fact that the consent order by which...
If they discontinued the High Court proceedings, they could simply have commenced proceedings in the CAT, which would have been in time, wouldn't they?
My Lord, they could have done, they didn't.
It's not resurrecting.
Well, my Lord, it is resurrecting, because what they did is they transferred the existing claim, which was itself time-barred. My Lord, that is the issue indeed, but we say it is resurrecting.
Yep.
The consent order by which the claim was transferred contained an express agreement between the parties that it was not intended to alter, limit or exclude any limitation defence. I'm going to start with a very brief summary of the factual and procedural background. I'm then going to address what we say is the correct construction of the CAT rules and where in our respectful submission the Tribunal went wrong as a matter of construction, and that is our first ground of appeal. And I will then address our second ground of appeal, which is that the transfer order gave rise to a contractual estoppel, which we say precluded the claimants from asserting that the effect of the transfer was to resurrect their time-barred claim. So, if the Court could please start with Supplemental Bundle tab 5.
Yeah.
Tab 5 is the claim form which was issued in the High Court on the 19th of June 2019. And this, in our submission, is when the claim was made. The Court then turns to tab 6. There is an email of 20th of May 2021, which is the claimant's proposal to transfer the proceedings to the CAT. And the Court will note the third paragraph in this email where they say the claim form in the proceedings was issued on 19th of June 2019 with brief details of the claim. Particulars were not served due to a sequential series of standstill agreements between our clients and yours, it being the common interest to await a final decision of the Court of Justice before proceeding. Now that the Court of Justice has issued its final decisions, we consider that it's in the interests of all parties for the proceedings to be transferred to the Competition Appeal Tribunal. And the Court will see over the page that there was a request to confirm agreement to the attached draft order. The defendant's response is at tab 7. It's the letter of 4th of June 2021 from McFarland's on behalf of the relevant defendants. What they do by the second paragraph is essentially ask for more information as to why it was contended the matter was appropriate for the CAT and why the transfer should take place at that stage. And there was an express reservation of rights in the final paragraph where it says, for the avoidance of doubt, all the above mentioned defendants' rights are reserved in respect of your proposal in your 20th of May 2021 letter. This letter does not constitute on behalf of any of those defendants any admission, whether as to applicable law, process for service, jurisdiction, liability, and the relevant parties in brackets, including as to any defence or argument based on limitation, time bar, late cheese delay or related issue. The response from the claimants to that inquiry is behind tab 8.
Would it be right to say that what they were preserving there was the right to argue limitation?
Well, they were preserving their accrued, certainly when we get to the form of the order which was made, which essentially either contains or evidences the agreement between the parties, they were preserving those accrued limitation rights. That
such as they might be.
Such as they might be, indeed. Although the CAT has recognised in its judgment, I'll show the Court, that we did have accrued limitation rights in respect of the claim as it was constituted before the High Court.
You had accrued limitation rights in the High Court?
Yes.
You had a right to argue that they might or might not have any effect in the CAT.
Well, we would say that we have there is a time-barred claim in the High Court, and we have therefore a defence
In the High Court.
in the High Court. Yes, and it was the High Court claim which then got transferred. I was turning over to the claimant's response. This is the 9th of June, 9th of June 2021, tab 8.
Yep.
And they say, second paragraph, as our email made clear, the aim is not to file and serve particulars and only then transfer to the CAT. That would involve unnecessary duplication and a degree of OTO's work by both parties. We wish to transfer the case to the CAT and then file a claim form complying with the CAT Rules 2015, including Rule 30 as regards any service outside the jurisdiction, Rule 31. And they elaborate on their reasoning for doing so in the 4th paragraph, part way down towards the bottom of the page. They say the particular reason for this date is, to answer your final query, that the extant standstill agreements relating to filing and serving particulars in the Chancery Division will come to an end on 25th of June 2021. Those agreements, and indeed the filing and serving of particulars in the Chancery Division instead of a claim form in the CAT, will, if our proposed order is obtained, become redundant. Instead of particulars in the Chancery Division, the CAT's requirements of a detailed claim form with the appended decisions and other documents will be required for the claim to proceed. Now, as the Court of Appeal will be aware, it is a peculiarity of the CAT's rules that rather than having a claim form and a separate particulars of claim, the CAT rules have a single detailed document which is described as a claim form, but it performs two separate functions. It both initiates proceedings in the normal way as a High Court claim form would do, and it is also essentially doubling up as particulars of claim. And what the claimants are proposing in their correspondence is that in this case, rather than duplicate the exercise of particularising their claim in a particulars of claim in the High Court and then transferring to the CAT and producing a claim form in the CAT, they would simply produce the claim form in the CAT instead.
Yep.
There was then an email from the defendants in tab 10. This is 18th of June 2021, and the second paragraph indicates, subject to the parties being able to agree the terms of any transfer, the defendants are in principle prepared to consent to the transfer of the High Court proceedings to the CAT. And the first bullet point, they say we are content, following the transfer of the proceedings, for your clients to file a CAT claim form in lieu of High Court particulars of claim. And the same reservation of rights was then made at the bottom of the page. As before, for the avoidance of doubt, all the above-mentioned defendants' rights are reserved in respect to the proposals, and this correspondence does not constitute, on behalf of those defendants, any admission, whether it's to applicable law, etc. And it's the same wording that I showed your lordship.
Can I understand what the relevance of this correspondence is? Are you saying that it qualifies the terms of what is found in the transfer order?
Our case on the transfer order is that there was either an agreement which is contained in the transfer order, or the parties' correspondence which predated the transfer order constitutes the agreement which is then evidence in the transfer order. And so
what is the particular document that you rely on as the agreement?
we say the agreement is either contained in the transfer order or evidenced in the transfer order.
So it's
The transfer order, isn't it? I mean, that's what we should be looking at.
Yes, well I
Because
can...
whatever went before, in one sense, is neither here nor there, because the parties then are submit to the court a consent order which is endorsed by the judge, and that's what contains any agreement,
Yes, well
I would have thought.
we have, out of an excess of caution, put it in two alternative ways. We've said either the agreement is the transfer order, or there was an agreement concluded in the exchange of correspondence between the parties, but its terms are evidenced in the transfer order. So I can show the court the transfer order. It's at tab 15 in this bundle.
15, isn't it?
15.
Yeah.
And the first recital records the fact that the claim has been issued in the High Court of Justice Chancery Division on the 19th of June 2019. Over the page, the 9th recital, which is the penultimate recital, records the facts that the parties have agreed to this order in draft form.
Yep.
The relevant paragraph providing for the transfer is paragraph 2. The claimant shall serve the High Court claim form within 7 days of receipt of a sealed copy of this order, at which point these proceedings shall be transferred to the Competition Appeal Tribunal pursuant to section 16(4) of the Enterprise Act 2002. Also relevant are paragraphs 6 and 7, and we say that they fall to be read together. Paragraph 6, the requirements for the claimants to file particulars of claim in the High Court, for the defendants to file acknowledgements of service in the High Court, are hereby dispensed with. And then paragraph 7, the claimants shall in due course instead file a claim form with the CAT in accordance with Rule 30 of the CAT rules. And in our submission, the word instead is important because it is telling us that the function of filing the claim form in these circumstances is instead of filing particulars of claim in the High Court. And in that respect, it echoes the correspondence that I've shown your lordships, which said in lieu of particulars of claim in the High Court.
Paragraph 2, I was puzzled. It may not matter, but paragraph 2 talks in terms about serving the claim form within 7 days.
Yes.
And then paragraph 7 really makes it clear that they're going to need to serve the claim form out of the jurisdiction. That's to say that the CAT claim form.
Yes,
So
paragraph
I'm not
2.
sure how paragraph 2 could have been fulfilled because permission to serve out of the jurisdiction was required, wasn't it? Or do they mean serve on the solicitors?
Paragraph
Who are you
2 was
gonna serve
envisaging
on?
the claim form in the High Court claim form.
Well, who are they going
Paragraph
to serve
7,
it on? Because it needed permission to serve out, didn't it?
I believe it was served. I think I'm right in saying that it was that the solicitors consented to accept service within the jurisdiction
Of the High Court claim form.
of the High Court claim form. Yes,
Right.
perhaps those behind me can confirm whether that was the position.
Well, it's a bit of a puzzle, that's all. Don't think it makes any difference.
Is it your case that anything said in this order can affect the scope and effect of the tribunal rules, or do you accept that they're always subject to whatever might be in the tribunal rules?
I accept that there are two separate questions. Ground 1 of our appeal concerns the construction of the tribunal rules, and the transfer order is not directly relevant to the exercise of objective construction, albeit that it is necessary to know, we say highly relevant to know, that this is the circumstance of a transferred claim rather than making a new claim. And so when one comes to apply the CAT rules properly construed, that is, in our submission, a highly relevant factor. Where the transfer order does become relevant is our second ground of appeal, because we say it gives rise to a contractual estoppel between the parties.
Just paragraph 7 of the order, the claimant shall in due course instead file a claim with the CAT in accordance with the rules. So all it is doing is directing the parties to comply with the CAT rules. The word instead, does that add anything?
In our submission, it's very important, and that's why I make the submission that it should be read with paragraph 6, because it is the parties are articulating their agreement as to the legal effect of filing a claim form with the CAT in accordance with Rule 30 of the CAT rules. They are saying dispense with the obligation to file particulars of claim in the High Court, instead file a claim form in the CAT. And so in our submission...
Assume that's correct. How does that affect? Well, I don't think you do say that it affects the scope or effect of the CAT rules. They're self-contained.
It doesn't affect the construction of the CAT rules. This becomes particularly important when we come to our second ground of appeal, because we say this is an agreement between the parties as to the legal effect that is to be ascribed to the action of filing a claim form in the CAT. It is not intended by the parties to initiate a new claim. It is intended to function as a particulars of claim, a substitute for particulars of claim only.
So do you accept the CAT rules are self-standing and comprehensive? In which case, are you saying that the construction of those rules is in any way affected by what happened outside the scope of those rules? On ground 1.
Well,
For example, in
You
relation to the
could,
word
you could obviously
commencement
you
or-
could obviously agree in a transfer order to waive some of the CAT rules. You could agree, or you could agree that a different regime should apply. Or, for example, they could have agreed in terms that, notwithstanding Rule 119 and Rule 31 of the 2003 rules, that the provisions of the CPR should prevail. I mean, that could have been agreed, but it wasn't.
And the CAT might not have
Yes.
agreed with that. It was
well,
still-
indeed, it would always be subject to and a proper construction of the rules as to whether it was possible
Yeah, quite.
detract from in that way.
Because as my lord puts to you, I mean, the cat is, it has a self-contained regime and its own rules,
My lord-
which are not the same as the CPR.
My lord, we accept that, and I'm going to come on to what we say is the correct construction of those rules.
Incidentally, the answer to my point earlier, I think, is the third recital, top of page 85, which actually expressly makes the point.
I'm grateful, my lord, yes. Just before we move off the transfer order, I was going to draw your lordship's attention to paragraphs 9.1 and 9.2, which are concerned with the preservation of rights on transfer. Paragraph 9.1 is concerned with the preservation of the claimant's rights. Paragraph 9.2 is concerned with the preservation of the defendant's rights, and we say they are counterpart to each other. They begin with essentially the same formulation of words. Neither this order giving effect to the said transfer nor the transfer itself is intended to alter, limit or exclude in respect of any element of, so the same wording for both of them. Then paragraph 9.1 refers to the claimant's claim as constituted in this court, being of course the High Court prior to the transfer taking effect. And paragraph 9.2 refers to the defendant's accrued rights in respect of defence to the claimant's claim as constituted in this court prior to the transfer taking effect. And so essentially what the order is doing in our submission is providing that the fact of the transfer doesn't alter the substantive position as between the parties or their substantive entitlements as they stand in the High Court as at the point of transfer.
And is the word accrued rights in 2 could relate to the latter part of 9.1, which is any part of the claim which turns out to have to be retained in the High Court because it's not within the jurisdiction of the CAT. So claimants preserve their right to hang on to things in the High Court if they're not in the CAT, and you wouldn't want to lose your accrued rights in those circumstances.
In my submission, that's not what 9.2 is doing. It is essentially providing, in an even-handed way, for both the claimants and the defendants, that the fact of the transfer is not going to affect their substantive position in the claim.
No, because that's not what it says with respect to this for. It says any element of the defence accrued rights in respect of defence to the claimant's claim as constituted in this court prior to the transfer. So it's basically saying if you've got a right of limitation in the High Court prior to the transfer, then that accrued right is preserved. But it's saying nothing about what happens once you're in the CAT.
My lord, I think
No,
we are
it's
saying
not my
essentially
earlier
the same
point.
thing.
It's not saying, and what's more, when you're in the CAT, the same limitation rules will apply.
My lord, that's absolutely accepted. I think I'm not disagreeing with your lordship. What it is doing is preserving the party's substantive position as it was in the High Court.
Yeah.
In case it's relevant, I'm not sure whether it is or not. Limitation isn't a substantive defence, is it?
Your lordship's right, it's not.
Right.
But it is expressly preserved in the wording of 9.2. So it is the wording in brackets, including as to any defence or argument based on limitation, time bar, late cheese, delay or related issue. So the parties have in my submission expressly preserved such limitation, defence or argument as they had before the High Court.
It's a matter of procedure.
Yes.
So it's the defences, the limitation defences, which had accrued to that point as a matter of procedure.
Subject to, I'm going to take your lordships to a series of cases in Merrick where an accrued limitation right is of relevance to the construction of rules because essentially the provision is that one doesn't construe rules in such a way as to undermine an accrued limitation right unless it's an unavoidable consequence of construction. So subject to that point, yes. So just to complete the very quick trip through the procedural situation, the transfer order was then provided by the claimants to the CAT in their letter of the 4th of August 2021, that's behind tab 18. Paragraph 1 encloses a copy of the sealed consent order and explains that it provides for transfer of the proceedings to the CAT upon service of the High Court claim form. Paragraph 2, a copy of the High Court claim form was also provided to the CAT. And paragraph 3, the claimants expressed their intention to file a claim form with the CAT in accordance with the tribunal rules brackets, this replacing the need to serve full particulars in the High Court, only to transfer the case in near parallel. On the 20th of October 2022, the claimants then wrote to explain that they were going to make an application to add a further defendant, Lundbeck UK Limited, to the claim. That's behind tab 21, and I mention this because it is relevant to the claimant's respondent's notice point about the status of the 12th defendant. And in the context of so doing, if the court turns over to page 102, the top of the page, the claimants made the point that if we were going to start the proceedings from scratch in the CAT, then we would not need permission to add Ranbaxy. And so the premise of their position is that they are not starting new proceedings. The claimants then applied with consent to add the entity that was by that point called Sun Pharma UK Limited as a defendant to the existing proceedings. That is behind tab 23. This is the letter to the registrar, which provides paragraph 2. Parties have agreed Sun Pharma UK Limited will be added as a defendant to the proceedings. There's a draft order at 109. The first recital records again the fact of the transfer of these proceedings from the Chancery Division to the CAT. And then the fifth recital towards the bottom of the page records the position of the legal representatives of Sun Pharma, having confirmed in writing to the claimant that they are acting for Sun Pharma UK Limited. Sun Pharma UK Limited has agreed to be joined as a defendant to these proceedings, and they have been instructed to accept service of the claim form at the business address within the jurisdiction. Accordingly, paragraph 2 of the draft order then provides for Sun Pharma to be added as the 12th defendant to these proceedings. The claim form itself, the CAT claim form, was then duly filed on the 28th of February 2023, and that is in the core bundle, tab 20. The court will note that the claim form, the case number on the front includes a T, indicating that this is a transferred claim from the High Court. The 12th defendant at this stage is included in brackets in the heading on the front page. The court looks at page 247 within the claim form. It records that the claim form is accompanied by an application by consent to add Sun Pharma as D12, and there's a further reference to that application, page 258.
The nature of the claim had changed on transfer from a standalone to a follow-on.
Certainly it was unspecified in the High Court claim form what it was, but it was very clear that the intention was, by the time of filing the claim form, that it would be purely a follow-on payment.
We saw that in the correspondence, didn't we?
Yes, absolutely.
Yeah.
I was just showing your lordships the reference to Sun Pharma and the application to add them in paragraph 45.2 on page 258. And then if the court turns over the page to page 259, paragraph 47.6 correctly records these proceedings were originally issued in the High Court of England and Wales before being transferred to this tribunal. If we go back, please, to the supplemental bundle, there is then an order adding 12th defendant, which is behind tab 26. And it contains essentially the provisions that I highlighted in the draft order, so a recital referring to the transfer, first recital, a recital recording Sun Pharma's agreement to be added as a defendant to these proceedings, and then paragraph 1 of the order on page 123 is providing for the addition of the 12th defendant. And then behind tab 27, the claimants then provided their amended claim form on the 17th of March 2023. The defendants then pleaded their defences, and they contended that the claim was time barred under the Limitation Act 1980. There was then an order of the tribunal, which is behind tab 32. Tribunal's order of the 29th of September 2023, and it directs at paragraphs 1 and 2 a preliminary issue on whether the claim is time barred. The court will note paragraph 3, the claimants had sought and were granted permission to amend their reply to plead a case of deliberate concealment based on section 32 of the Limitation Act 1980. And paragraphs 4 to 9 in this order set out directions for disclosure, including an obligation on the claimants to provide disclosure in respect of the preliminary issue. The claimants did then duly amend their reply to plead deliberate concealment, but shortly before the deadline for providing disclosure in respect of that issue, they conceded that the High Court proceedings had been brought more than 6 years after they had sufficient knowledge of the purposes of section 32(1)(b, and that concession is recorded in the judgment of the tribunal at paragraph 9. And so the preliminary issue that was before the tribunal then proceeded on a much more limited basis, and it essentially considered the construction of the CAT rules and our argument on contractual estoppel. So I'm moving on to address the question of construction of the CAT rules. The question for the tribunal in determining the limitation preliminary issue was whether the claim was governed by the Limitation Act 1980, in which case it was out of time, or the 2-year time limit in Rule 31 of the CAT Rules 2003, in which case it was in time. Whether the 2-year time limit in Rule 31 applies turns on the construction of the savings and transitional provisions, which are contained in Rule 119 of the CAT Rules, and they are in the authorities bundle at tab 23.
Tab 23.
23, my lord, yeah. Page 569. Paragraph 119, subparagraph 2, provides that Rule 31 1 to 3 of the 2003 rules, brackets time limit for making a claim, continues to apply in respect of a claim which falls within paragraph 3. Just pausing there, this is a claim which falls within paragraph 3. It's a claim to which section 47A of the 1998 Act applies, and the claim arose before 1st of October 2015.
Yeah.
Going back to subparagraph 2, it applies for the purposes of determining the limitation or prescriptive period which would apply in respect of the claim if it was made on or after 1st of October 2015 in proceedings under section 47A of the 1998 Act. So whether the limitation rules in Rule 31 1 to 3 would apply depends on whether they meet that condition in Rule 1192, that the claim was made on or after 1st of October 2015 in proceedings under section 47A of the 1998 Act. Our submission is a very straightforward one, and we put it the same way before the tribunal. We say that condition is not satisfied. The claim was not made in proceedings under section 47A of the 1998 Act. It was made in the High Court, and then it was transferred to the CAT. So this really turns on what is meant by making a claim. In our submission, reference to making a claim means commencing proceedings. We say that's a natural and obvious meaning of the words. And we also say that that's what the CAT rules themselves provide when they refer to making a claim. They equate making a claim with commencing a claim. And we can see that in 3 places in the rules. The first is in Rule 30 on page 558.
(558).
558, Rule 30. This is the provision on which the claimants rely to say that they filed a claim form and therefore they've made a claim. Now, the court will note that Rule 30 appears in Part 4 of the rules, and it's headed in block capitals, claims under Section 47A of the 1998 Act, commencement of proceedings. And Rule 30 itself then has its own heading, manner of commencing proceedings under Section 47A of the 1998 Act. And then Rule 30 subparagraph 1 provides a claim under Section 47A of the 1998 Act, brackets proceedings before the tribunal, claims for damages, etc., shall be made by filing a claim form. So in our submission, Rule 30 subparagraph 1 is clear that making a claim means the same thing as commencing proceedings. It is well established that headings may be taken into account in construing legislation, and we have cited the relevant excerpt from Bennion for that proposition. To show the court that very quickly, it's behind tab 25 in this bundle. The relevant passage is at page 583. At the bottom of the page, section 16.7 headings, where it says a heading is part of an act. It may be considered in construing any provision of the act, provided due account is taken of the fact that its function is merely to serve as a brief guide to the material to which it relates, and that it may not be entirely accurate. And then the same applies in respect of delegated legislation. The court will see that, page 593 within this tab. There's a heading, delegated legislation. And then towards the bottom of the page, there's a subheading, headings, and it says headings may be referred to in interpreting delegated legislation, but it is important to bear in mind that the function of a heading is merely to serve as a brief guide to the material to which it relates and may not be comprehensive.
Yeah.
So if we go back to the provision of the rules that we were just looking at, tab 23, page 558. In our submission, the headings to Rule 30 are a powerful indication, and this is the tribunal rule on which the claimants themselves rely. They're a powerful indication that making a claim means commencing proceedings.
Well, it says expressly what making a claim is, and it's made by filing a claim form.
My lord, that's the approach the tribunal took. In my submission, it is not right to say that making a claim means going through the procedural steps which are identified in this rule. That is what is procedurally necessary, but the meaning of making a claim in my submission is commencing a claim.
That's how we normally deal with limitation, isn't it? By a party has to comply with certain procedural requirements by a particular date, in this case 2 years.
My lord, yes, what they have to do is commence their claim.
No, they have to make a claim.
My lord, yes, and in
And
my
that is
submission,
made by filing a claim form.
that's the
It's absolutely black and white, isn't it?
that's the steps of filing a claim form are the way in which it's specified one makes a claim, but not in my submission in circumstances where the claim has already been originated outside the jurisdiction and one is filing a claim form.
Well, you start off by showing us that the question, and you yourself say the question is making a claim. What does that mean?
Yes.
And you have an express explanation here of what is making a claim, but what you're trying to do is to avoid that express wording by introducing the concept of commencing to qualify what is making. But you don't need to do that. There's no need to put anything between provisions you've shown us, which is, it says expressly make a claim, and then it says a claim shall be made by filing a claim form. It doesn't seem to me it could be any clearer.
My lord, when your lordship puts to me that I have introduced the concept of commencing a claim, that derives from the headings to this provision, commencement of proceedings, manner of commencing proceedings. That, in my submission, is what this provision is dealing with. It's about commencing a claim.
But it may well be, but then it tells you, if making is commencing, it tells you how you make and therefore commence.
My lord, in my submission, it tells you the procedural steps by which one would ordinarily go about making a claim, but it's not a definitional provision. It's not saying making a claim means taking these procedural steps. It's
What
saying
you're doing is you're trying to introduce the concept of commencing in order to undermine the express wording, so that in fact making a claim doesn't mean issuing a claim form, it means something else.
well, my lord, in my submission, in circumstances where the claim already exists, the claim already has been commenced, making a claim does not mean simply following the procedural steps that have been identified in order to make that claim, because it's already existing. It has been transferred into this jurisdiction.
But we know that a claim was issued, and that will have a claim number. It will be a new claim in any procedural sense. It may be that it has a history, but it is a claim, and that's what we look at in limitation cases. When was the claim issued? Was it within the relevant limitation period?
My lord, in my
Seems
submission,
very simple.
in my submission, the claim was not issued at the point where the claim form in the CAT.
Do you think a claim form isn't a claim?
The claim form in the High Court originated the proceedings. The proceedings were then transferred into the CAT. A claim form was produced in order to satisfy the requirement of particularising the claim in lieu of particulars of claim in the High Court. That, in my submission, is not making a claim within the meaning of these provisions.
I still have some difficulty with the idea that you construe these rules by reference to anything which goes before. So if you look at the word commencing, it has to have the same meaning as made. Otherwise, one's bringing in extraneous material. These rules are self-contained. They relate only to proceedings in the CAT. You make a claim by filing. Ergo, that's how you commence the claim.
My lord, I don't disagree that commencing and made have to mean the same thing. That's absolutely my submission. But my submission is what they mean is starting the claim, originating the claim, and that has already happened. That happened
But
in the High
you're
Court.
then importing what happened before as a guide to construction of something which almost by its Rule 3 says these rules relate to proceedings in the CAT. That was in the 2003 rules and the 2015. It's self-contained. So one's bringing in this sort of pre-life history and using it to interpret something which is intended to be a self-contained, hermetically sealed set of rules.
Yeah, I mean, the rules say if you issue a claim form in the CAT, you've made a claim. They don't say, unless of course it's a transferred in claim, in which case it's not actually, the claim isn't made then, the claim is made at some distant point in the past when you issue proceedings in the High Court.
How does it have any lingering half-life or full life? What happened before? It's almost a matter of constitutional interpretation of the rules. They're self-contained. Whatever the judge got it right or wrong, the parties got it. He understood it rightly or wrongly. What does it matter?
I don't seek to suggest they're anything other than self-contained. I do say that on a true construction, this rule is not saying making a claim means the process of pursuing these procedural steps. In my submission, read in the context at least of these headings, and I'll show the court other places where the same applies, making a claim means commencing a claim, and it cannot apply in circumstances where the claim is already extant, it already exists. It has already been made.
That's the point, isn't it? You say it only exists and it's extant because of what happened before, whereas this tells you what happens de novo. You start again. And if the High Court thought it was transferring something which had a lingering existence, it doesn't, it can't. The CAT could, I suppose, say, well, the particulars of the claim are very detailed. We order that they suffice as a claim form for the purpose of Rule 30, but they didn't. A claim form was issued. Why don't you just start de novo, whatever the transfer says?
In my submission, it is something of a procedural happenstance that a claim form was issued in this case, because the parties reached a pragmatic agreement that rather than require particulars of claim in their Chancery division, they produced the claim form in the CAT instead. It's unsatisfactory in my submission for that procedural happenstance to dictate whether or not a claim is deemed to essentially arise de novo in the CAT, or whether a claim is transferred from the Chancery Division. And it also has the potential to act to the detriment of claimants insofar as they start a claim in the High Court, which is in time, they then transfer to the CAT, and then they produce a claim form, and that essentially applies the CAT limitation provisions and causes their claim that had originally been in time to be out of time. And we'll see when we come on to look at the Sainsbury's authority that was a very genuine concern, and one that Mr. Justice Barling, at the time President of the CAT, considered didn't arise precisely because these provisions, he found, didn't apply to transferred claims.
Well, I'm sure we'll come on to what Mr. Justice Barling did. I mean, all that's happened in all those cases is that the court has bent over backwards to preserve a claim, never to extinguish it.
Yes, well, that may well be true.
Yeah, there's a certain amount of forensic sleight of hand, I think, in that case. But he did it in order to preserve a claim and prevent an injustice. He could have said, stay in the High Court, but everybody, and of course, he didn't. He transferred it, and then no one took the points.
In my submission, there is a certain risk that the same might apply, in the sense that if on an ordinary...
He could have said, I'm going to leave the case in the High Court unless you, the defendants, waive any suggestion if the claim's transferred to the CAT, it will be time barred. Because it, you know, as we know, the Sainsbury's case was around the time when there was an issue about the fact that proceedings had been, a number of the MIF claims had been issued either in the Chancery Division or in the Commercial Court, or even transferred actually from the Chancery Division to the Commercial Court in the case of one of them, as opposed to the CAT. And ultimately the Court of Appeal in Sainsbury's said it should all have been in the CAT, but it was at that time, as you know, which is now whatever it was, 10 years ago, there was a sort of bit of a debate as to where these claims should be started. But if the parties had wanted the case in the CAT, the judge could have said, rather than doing what he did, I mean, he did what he did, no doubt, because that's what he was asked to do. He could just have said, well, I'm going to leave the case in the Chancery Division unless you, the defendants, agree not to take a limitation defence if it's transferred. So if you want the case in the CAT because that's the right place for it to be heard, you're going to have to agree that there's no limitation.
Yes.
This case is, of course, the other way around.
It is the other way around, and it is a case in which the parties expressly turned their mind to limitation.
And also the other way around, I think, it was completely the other way around. Yeah,
it was the opposite.
yeah, it's completely opposite.
This is, however, a case where the parties did make express provision as to what should happen on transfer in respect of limitation, and that's subparagraph 9.2 of the transfer order.
Well, depends how you interpret that provision.
It does. I'll come on to make my submissions on that.
Yep.
I was showing the court what, in my submission, are the three places in the rules where commencement of the claim is equated with making a claim.
It's Rule 30.
Rule 30 we've looked at. Rule 119 itself, which is the
we looked at.
transition provisions, that's page 569.
Sorry, 549.
569
565.
within tab 23.
Yeah. Oh, yeah.
This is the provision we were just looking at. Rule 119.1 refers to proceedings commenced before the tribunal before 1st of October 2015, and it says that those continue to be governed by the Competition Appeal Tribunal Rule 2003. Rule subparagraph 2 concerns a claim which is made on or after 1st of October 2015.
Which arose before the 1st of October. So the cause of action is pre-1st of October.
My lord, yes.
I'm simply saying these rules continue to apply. And that was the issue that my lord and I dealt with in the Merck's appeal.
My lord, that's right, yes. What in my submission is going on, as between subparagraph 1 and subparagraph 2, is that they are drawing a temporal distinction. Subparagraph 1 is concerned with claims commenced before October 2015. Subparagraph 2 is concerned with claims commenced on or after 1st of October 2015.
Yeah.
And so, in drawing that temporal distinction, what they are doing is treating the words commenced and made as being the same. because 1191 refers to commenced and 1192 refers to made. The third place in the rules where we see this equivalence between making a claim and commencing a claim is Rule 31 of the CAT rules, which is the limitation provision that the CAT has found to apply. That's behind tab 21 in this bundle, page 549. This also appears under a heading in block capitals, claims for damages, commencement of proceedings. And then there's a sub-heading, time limit for making a claim for damages. And Rule 31.1 then provides a claim for damages must be made within a period of 2 years, beginning with the relevant date. So again, the rules are equating commencing proceedings and making a claim. And in the DSG retail case, this court described this rule, Rule 31, as a new limitation period in respect of a new way of bringing follow-on claims through the tribunal. In my submission, we know that limitation provisions are concerned with the point at which proceedings are commenced. That's what the focus of any limitation provision will be. And so again, references to making a claim in the context of a limitation provision are clearly, in my submission, references to commencing a claim. Can I ask the court just to note the content of subparagraphs 3 and 4 because they're relevant to both the Sainsbury's case and the Merck and Mastercard case. Subparagraph 3, the tribunal may give its permission for a claim to be made before the end of the period referred to in paragraph 2A after taking into account any observations of the proposed defendant. So the tribunal's permission is required to make a claim when the decision on which it's based is not yet final. And in my submission, that obviously has in mind commencing proceedings for the first time before the tribunal. And then subparagraph 4, no claim for damages may be made if, were the claim to be made in proceedings before a court, the claimant will be prevented from bringing the proceedings by reason of a limitation period having expired before the commencement of section 47A.
Yeah.
That provision in my submission is equating making a claim for damages with the point at which proceedings are brought for the purposes of limitation periods. So the tribunal, the court has my submission. This is not a claim which was made in the CAT within the 2-year limitation period provided for in Rule 31. It was made in the High Court in 2019, and we say transferring the already constituted claim over from the High Court to the CAT doesn't constitute making a claim. We do derive support for our construction of the rules from the reasoning of Mr. Justice Barling in Sainsbury's and Mastercard. That is in tab 5 of the authorities bundle. This was, as the court recalls, the first transfer of proceedings from the High Court to the CAT. It does contain some consideration of the legislative background. We'll see, for example, the provision, the wording of 16.4 of the Enterprise Act 2002 is quoted in paragraph 7 on page 145. That's the provision which says, in accordance with rules of court, transfer to the CAT so much of any proceedings before it as relates to a claim to which section 47A of the 1990 Act applies. Paragraph 24 the claimant's solicitors had raised a query concerning the construction of Rule 119 of the CAT rules, and they sought clarification on it, and the particular concern raised was, as we've already canvassed, the opposite of the issue that arises in this case. So they were concerned that transfer to the CAT might render out of time a claim which was in time in the High Court by reason of the short limitation period, the 2-year limitation period in the CAT. And I do make the submission that that is an important point to bear in mind, because if the tribunal were to be right in the construction of the rules that it has put forward, the transfer of a claim could equally operate to the disadvantage of claimants by rendering their claims out of time. Mr. Justice Barling gave his answer to that, page 148, paragraph 27. And he says, whatever the precise ambit of Rule 119, in my view, it could have no application to the proceedings such as the present if they were transferred in whole or in part to the CAT pursuant to Section 16 of the 2002 Act. The present proceedings have been commenced in the High Court. Therefore, what would be transferred to the CAT in such a case would be all or part of an existing claim, whereas it is in my view clear that Rule 119 is only dealing with claims originating in the CAT. In our submission, Mr. Justice Barling was entirely correct to be drawing that distinction. The key reasoning for our purposes is in paragraphs 29 and 30. And in particular, it's the second and third points that he makes in paragraph 29. So second starts halfway down that paragraph. He says, second, it is in my view not a claim made in proceedings under Section 47A of the 1998 Act within Rule 119.2. New Section 47A concerns the right to make a claim in proceedings under this section. That is not an apt description of the present claim, which was made not in proceedings under that section, but in the High Court under the latter's own jurisdiction, which is not dependent on new or old Section 47A. That, in my submission, applies equally in the present proceedings. And then the third...
Do we apply the same principle, that you construe the rules to preserve the claim?
In my submission, you should be construing the rules according to the ordinary and natural meaning of the words. The ordinary and natural meaning of the words make and commence, in my submission, is exactly the same. It means starting the proceedings. It doesn't encompass proceedings which have already been commenced in the High Court and are transferred over.
So what he's saying is, when he uses the word, whatever the precise ambit of 119, he's saying, I'm not giving a definitive conclusion, but if I then paraphrase it into judicial pragmatism, I'm damned if I'm going to see this case extinguished.
My lord, in my submission, that's not what was going on. What is, when he says whatever the precise
There's
ambit...
a difference between what's going on and how he analysed 119.
If your lordship looks at paragraph 30, he says, regardless of whether Rule 119 and Rule 31 of the 2003 rules applies only to follow-on and not to standalone claims, which the claimant's solicitors say is a subject of current debate. So he was mindful that there was some confusion at the time as to whether it was capable of applying both to standalone and to follow-on claims. He was saying, I'm not getting into that, but he was saying, in any event, it doesn't apply to transferred claims. And in my submission, on a true construction of the rules, he's absolutely right, because made means commenced, and a transferred claim has already been made outside the CAT in the High Court.
He says a couple of times, in circumstances such as the present, where the case is not to be extinguished and is in time. I mean, we understand the point. I mean, we understand where he got to, and perhaps we have a view as to how he got there. But whether or not you can turn that around and say it applies to extinguish a claim which is otherwise validly formed in the CAT, perhaps tests this to destruction.
Just on the, as it were, on the happenstance that the claims remains transferred, although there is then a claim form in the CAT, so Rule 30 claim form, because there's no other rule that says that in effect you have to issue a claim form. In circumstances where if they'd simply discontinued, we wouldn't be sitting here.
And pays the costs. I mean,
It's a cost issue, isn't it, really?
a cost issue at the end of the day.
Well, we're not privy to what the claimant's reasoning was. We do say it's material that they didn't
It
discontinue
probably
and bring
is
a
a
new
cost
claim.
issue, because if they discontinued, they'd have had to pay the costs of the High Court.
It's certainly true that had they taken that route, they would have done. In our submission, had they taken that route, they would have made a claim in the CAT, but they didn't. And my submission is doing violence to the wording of the rules, which refers to make a claim and equates it with commencing a claim, to say that that is capable of encompassing a claim which has already been made in the High Court and which is transferred over.
And
It may well be...
Another way of looking at it is to say that there's nothing in the CAT rules that says that if you issue a claim form in circumstances where it's been transferred in, it has a different, the claim form has a different status to the claim form which is issued, as it were, without any previous history. And it's the point my lord put to you before, that these rules don't talk about previous history at all.
My lord, that's entirely true, but one
There
still
is
has
a
to
rule dealing
ask.
with transfers, 76, I think it is it? which number it is now, but there is a rule that deals with transfer.
I don't, yeah.
72.
The only reason
72.
that one is in Rule 30 about about a claim form is because they hadn't yet particularised their claim in the High Court. And that is, in my submission, a potentially arbitrary distinction. Had they produced particulars of claim in the High Court and then transferred it over to the CAT, there would be no mechanism by which one could say that that somehow had given rise to a new claim.
I'm not certain. I mean, the CAT has powers under Rule 4, it has powers under, was it 70-something to cure irregularities. It can basically, it could very easily just issue the direction. The particulars of claim issued in the High Court shall henceforward stand as the claim form for the purpose of the rules.
It absolutely could have done.
And why wouldn't that have been a new claim form? It wasn't treated, it was reclassifying legally the particulars of claim as a claim form. Why wouldn't that then say, we don't accept particulars of claim being transferred in, we require the rules to be complied with. Now, matter of pragmatism, proportionality under Rule 4, we can take any step we like. We now treat particulars of claim is now claim form. So start again.
Well, the end of your lordship's question is in my submission the key one. Yes, absolutely, they can say we treat the particulars of claim as standing in the place of a claim form, but query whether it would be the intention of the tribunal in those circumstances to start again and make a new claim. In my submission, it wouldn't, because the claim has already been made and it's being transferred in from another venue.
Why would it have to even think about that? It just simply says under Rule 30, the claim has been made. Button A has been pressed, things now start. Would it have to classify it as old, new, transferred, transmogrified? Just simply says procedures now started.
In my submission, yes, it does, because what is meant by made on a fair reading of Rule 30 is to commence the proceedings.
It comes back to that answer.
It comes back to that answer.
There is one distinction with Sainsbury's, which is that there was no new claim form.
Yes, and the tribunal did identify that as a basis on which it was distinguishing Sainsbury's. In my submission, that is a procedurally unsatisfactory basis to distinguish it, because it is a happenstance, which essentially was a pragmatic agreement as between these parties to avoid duplication as between the High Court and the CAT. And in my submission, it shouldn't mean that what is functionally going on, which is the transfer of an existing proceeding, should then be treated as making a new claim. I was just showing the court the third element of reasoning from Mr. Justice Barling. It's the top of the page 149. He says it's clear from the wording of Rule 31 of the 2003 rules that Rule 2 applies only to claims originating in the CAT. He says thus the tribunal may give its permission for a claim to be made before the end of the period referred to in paragraph 2A. And then no claim for damages may be made if were the claim to be made in proceedings brought before a court, the claimant will be prevented from bringing the proceedings. So he's again deriving from the rules the intention that it only applies to claims originating in the CAT, not claims being transferred over, and that's the conclusion he then expresses at 30. He said regardless whether it applies in both follow-on and standalone claims, it would have no application to the present proceedings if they were transferred in whole or in part to the CAT under section 16. I can see no grounds on which it could reasonably be argued that a different limitation period would apply by reason of a transfer in circumstances such as the present. In my submission, it is not a fair characterisation of what Mr. Justice Barling was doing to suggest that he was simply bending the rules in order to keep in effect an extant claim. He's
Never suggest that.
Heaven forbid.
Heaven forbid.
Were such a suggestion to be made in my submission, it would be an incorrect one. His perspective, his construction of the rules, he says it couldn't reasonably be argued that a different limitation period applies by reason of a transfer. As a final point of statutory construction, in our submission, it's important to emphasise that the effect of the
Well,
tribunal...
he may not be bending the rules, going back to that point. The very last paragraph of the order on page 151 does give one a clue as to what was really going on, with the avoidance of doubt paragraph. making it absolutely clear that the effect of what he was doing wasn't going to deprive the claimants of the rights they already had, or to give the defendants some right of limitation which they didn't have in the High Court. So he was obviously conscious that he better sort of seal off every escape route for the defendants as he could.
My lord, it's interesting your lordship makes
It's a
that
different
point.
situation from ours, obviously, because it's the other way around, but
It is the other way round, but this wording that your lordship's identified at 151 is essentially the wording that was then reproduced in the transfer order in these proceedings. And as your lordship's put it to me, the intention was essentially to preserve the position as it was prior to transfer. And in my submission, that was the parties' agreement in the transfer order in our case as well. I'm moving on to deal with the case of Merck and MasterCard. And the submission I make in respect of that is that the tribunal and this court have rightly been very wary of interpreting the CAT's transitional provisions in such a way as to override accrued limitation rights. Starting with the tribunal's judgment in that case, it's authorities tab 14.
yeah.
Judgment begins at page 345. If we look within that at paragraph 11 on page 350, there's the heading, the limitation prescription issue. The tribunal explains the issue in paragraph 11 as being MasterCard contends that in the case of claims governed by English law, as far as they are based on transactions prior to 20th of June 1997, they are time barred. And in the case of claims governed by Scots law, insofar as they're based on transactions prior to 20th June 1998, they're time barred. That's said to follow from the effects, respectively, of the English law on limitation and the Scots law on prescription, as at the time when the original Section 47A 1998 and the Competition Appeal Tribunal's 2003 came into force, 20th of June 2003, and then the contrary submission on behalf of the class representative was that all the claims are entirely within time, on the basis of Section 47A and Rule 31(1)(3), applied by reason of Rule 119, subparagraph 2. So
this was all being governed by the CAT rules.
this was being
What we
governed by
were
the
dealing
rules.
with, what the CAT was dealing with and what we dealt with in the Court of Appeal was an issue where you had a claim which under the CAT rules had become time barred. Time barred potentially years before in the case of some of the claims. Could the change in the CAT rules subsequently giving rise to the 2-year limitation period?
Yes, so
Preserving the 2-year limitation period, enable you to revive claims that were previously irredeemably time barred. I mean, that was the issue. So
That
it
was
was
the
all
issue.
in the CAT, it wasn't about transfer.
well, there was no transfer, your lordship's quite right. The time bar itself originated from the rules prior to the CAT rules coming into force. So
from the
it wasn't,
previous rules.
from essentially English and Scots law. It
Well,
wasn't.
they were Limitation Act rules, weren't they?
They were. So to that extent,
But
it wasn't.
as applied in the CAT, because there was not a separate limitation period. Isn't that
Well,
right?
subparagraph.
I can't.
I can show you lordship's point, but subparagraph 4 of Rule 31 provided that insofar
Yeah.
as there had been something which had already become time barred, it wouldn't.
Yeah, well, that was the
it
point
would
about
remain
Rule
time barred
31.4,
essentially, and so it's.
and the real issue was, well, they didn't include Rule 31.4 in what was preserved by Rule 119.
Yeah, your lordship recalls
Had
the point.
what was the effect of that?
Yes, no, that's absolutely it. But there is, it's not a purely self-contained CAT issue. It did relate to the accrued rights under the Limitation Act. So if we look at subparagraph 30,
In the CAT judgment.
in the CAT judgment, yes, so page 356. And this is the point that your lordship was just recalling. The present proceedings were started after 1st of October 2015, but comprised claims which arose before 1st of October 2015. Accordingly, they fall within Rule 119.3 of the 2015 rules and are therefore subject to Rule 119.2. They are therefore governed by Rule 31(1) to 3 of the 2003 rules. So we're essentially looking at exactly the same transitional provisions that the court is being asked to construe in this case as well. Paragraph 31 then cites section 16(1) of the Interpretation Act 1978, which states that where an act repeals an enactment, the repeal does not, unless the contrary intention appears, revive anything not in force or existing at the time at which the repeal takes effect, or affect any right, privilege, obligation or liability acquired, accrued or incurred under that enactment. And then paragraph 32 cites the Privy Council's judgment in Ubon 2, which says that an accrued right to plead a time bar, which is acquired after the lapse of the statutory period, is in every sense a right, even though it arises under an act which is procedural. It is a right which is not to be taken away by conferring on the statute a retrospective operation unless such a construction is unavoidable. So that is the applicable principle that's being applied. Paragraph 34 looks back to the Court of Appeal judgment in DSG, which had held that in competition damages actions started in the tribunal prior to 1st of October 2015, claims for which limitation period had expired before 20th of June 2003 remained time barred. And that was by virtue of Rule 31(4), which is the provision that I've shown the court that says that anything which was time barred before entry into the force of the rules remains time barred. And as your Lordship rightly recalled, the issue here was that the claims were after the 1st of October 2015.
They all commenced after the 1st of October 2015, so they were subject to the 2015 rules.
They were
and therefore only subject to Rule 31 to the extent that it was preserved by the 2015 rules, and that was the point.
Yes, so they were subject to Rule 1192 expressly applied, Rules 31(1) to 3. It didn't expressly refer to Rule 31(4), which was the one that says essentially that anything originally
that was the point I was making to you, that the claims had become time barred under the then CAT rules. So when the claim was commenced, claims relating to a limitation period which had expired on or before the 20th of June 2003 were time barred. Therefore, so all the claims before the 20th of June 1997, which some of them were time barred.
Yes.
Under the then rules. And the issue here was, well, given that you've now issued these claims after 2015, after the 1st of October 2015, and 31(4) is no longer there, can the claimants argue that the claims are somehow in time under the 2-year period, even though actually they would otherwise have been time barred for the last, goodness knows how many years, 15 years or whatever?
My Lord, that was absolutely
Which is
the point.
pretty sort of startling proposition, really.
It is. And the CAT understandably held that the fact that Rule 31(4) didn't apply wasn't enough to override previous limitation defences. And we can see partway down paragraph 34, what they say is Rule 119 of the 2015 rules does not express a contrary intention for the purposes of section 16 of the Interpretation Act, either to affect any pre-existing right of a defendant to plead a time bar by reason of the expiry of the limitation period, or to revive an obligation which had previously been extinguished by prescription. And they go on to deal with the fact that while it might be surprising that 31(4) wasn't actually expressly incorporated, it doesn't make any difference to the outcome. Paragraphs 35 to 38 in this judgment, the tribunal also rejects the submission that section 47A(4) can be interpreted as overriding limitation periods. And the reasoning at paragraph 39 makes clear that although the tribunal would have reached that argument as a matter of construction, they do again rely on section 16 of the Interpretation Act. They say this provision reinforces this conclusion, since the requirement to disregard limitation or prescription rules for a specified purpose is far short of a statutory repeal, nor does it express an intention more generally of an obligation extinguished by prescription or affect a right to plead a time bar in the clear terms that would be required. So that was the principle as applied in the tribunal, and as your Lordship will recall, the Court of Appeal upheld that approach. This is tab 15 in the bundle. Paragraphs 153 to 154 on page 421. Page 466. Passage in these paragraphs that we rely on, partway down 153, it's inherently unlikely that Parliament ever intended that claims which have become time barred by 20th of June 2003 should somehow be revived and become no longer time barred 12 years later. When the 2015 rules came into force, a conclusion to that effect would be highly surprising and illogical. In my judgment, this court should not reach the conclusion that accrued limitation rights were abrogated in that way, unless, as the Privy Council held in New Blonde Chew, that conclusion is unavoidable. Similarly, we say it is inherently unlikely that Parliament intended that the meaning of making a claim in the tribunal rules should be read so broadly as to include the transfer of a claim and thereby to revive a claim which, it is common ground, was time barred before the High Court.
You're not saying, are you, that you had an accrued limitation defence to follow-on claims?
I'm saying we had an accrued limitation defence to the claim as constituted before the High Court, which was then transferred. And the tribunal
So
accepted
the answer
that.
to my question is no, you're not contending that you had an accrued limitation defence to a follow-on claim under section 47A.
I'm afraid I may not be appreciating the significance that your Lordship is ascribing to the follow-on element of the claim. It's,
Well, as I understand it, the limitation period is 2 years after the infringement decision
in the CAT.
in the CAT. And you're not saying you had an accrued limitation defence against such a claim.
Against a new claim commenced for the first time in the CAT, within that time period, we would not have an accrued limitation defence to that new claim. What we say is that what happened here is that we did have an accrued limitation defence to the High Court claim, and that claim was transferred.
So that's a completely different scenario to what is being looked at in this case.
Well, my submission, the principle that derives from this case is that as a matter of construction, one doesn't construe the rules so as to defeat accrued limitation rights unless such a construction is unavoidable. And my submission is...
That's why I ask you, what accrued limitation rights do you say you have? I mean, as I understand it, there was nothing to stop the claimant from commencing proceedings in the CAT.
We accept that, and we
Under
say they
section
didn't.
47A,
Yeah.
within 2 years of the infringement decision.
That
So
was
you've not got an accrued limitation.
Exactly right, because that's the whole point about Merrick's, that it was no use Mr. Merrick's commencing the claim in the CAT after the 2015 in circumstances where the claim in the claims in the CAT which related to causes of action which had become time barred 12 years earlier couldn't be revived, but by the 2-year limitation period. But the position here is completely different, because they could, in fact, the claimants could have just have said, well, as we said earlier, they could have abandoned the High Court proceedings, paid the costs of the High Court proceedings, and commenced new proceedings in the CAT. None of the claim in the CAT at that point would have been time barred. Contrast Berwick's, where pre-20th of June 97 claims were all time barred for all time.
My Lord, we accept that if that's what the claimants had done, that new claim would not be time barred. We simply say that as a matter of construction of the rules, it is not right.
No, I'm not, I'm just...
Your Lordship has my point.
Can I just hang you a little bit more on parliamentary intent? Parliamentary intent in the case of a follow-on action is to say, let all the regulatory proceedings come to a terminal end after appeals, and then give 2 years. The claim as articulated in the claim form is as a follow-on action. Why would Parliament have wanted to stifle that simply because there was a transfer?
Well, that Parliament has a countervailing intent, which is the requirement of legal certainty in the context of the Limitation Act 1980. That Act, it is common ground, provides that the claim as commenced in the High Court is out of time. And the principles that are articulated in this case that we've just looked at say that that accrued limitation right to defeat that claim should not be undermined by means of statutory interpretation unless it's unavoidable. And my submission is far from unavoidable to conclude that what is meant by making a claim in the CAT rules is to originate a claim in the CAT, not to transfer one over from the High Court.
That's what your claim. That's what your whole argument here depends upon. Is the simple proposition that this is not a new claim in the CAT.
It does.
And that's the end of it. And even though a new claim form was issued in the CAT, that isn't really a new claim form.
It was a claim form which was performing the function of particularising an existing claim. And so I am essentially repeating the submission I've made to your Lordship earlier. Rule 30 is not saying that the concept of making a claim means following these procedural steps. In my submission, making a claim means commencing the claim, and the procedural steps are what is necessary in order to do so, but it's not a definitional provision. It's not defining making a claim to mean doing the following things. Making a claim, in my submission, means starting the claim in the CAT.
So at the time that they issued the claim form, what would they have had to have done to start a new claim?
They could have not transferred their High Court proceedings and started a new claim in the CAT.
So what would they then have done?
They would have issued a new claim form. It would not have been a claim form marked T for transfer, and it would not have been a claim form that was issued in the context of a transferred claim from the High Court.
Exactly the same. It would have been exactly the same thing, except for T on the claim form, and that means that they do not then gain the benefit of the 2-year limitation period.
My Lord, there is a substantive difference. There is a substantive difference between transferring a claim and starting a new claim. And your Lordship, it's emphasising the point.
Substantive differences here, which might be procedural differences, aren't we?
Well, they could even have on one view, they could just have left the High Court proceedings in abeyance and simply commenced a new claim in the CAT. Now, they might have been faced at that stage with an argument about abuse of process and making a choice. But they could, in fact, have issued a claim in the CAT at the same time as the High Court proceedings were still extant. And that new claim in the CAT, leaving aside any abuse argument, would have been in time.
My Lord, they absolutely could. The fact that your Lordships are putting to me these options about what they could have done merely underlines the fact that that's not what they did. They had a means by which they could have done this.
On one view, what it underlines is whether what they did is fundamentally different from what they could have done, as you say it was, in terms of the effect. And that's the point.
The substantive effect of what is going on, is it initiating a claim before the CAT, or is it simply particularising an extant claim?
What at the time, as well as issuing a claim form with a T on it, at the same time they'd issued another claim form without the T, and then asked for the two to be consolidated?
In that case, the claim form, insofar as what substantively they were doing is bringing a new claim by the new claim form, then we have no accrued limitation defence to that new claim. We do have an accrued limitation defence to the extant claim. And so one could consolidate them. We would say we have a defence to the claim originally started in the High Court. It may not avail us much because, of course, they then consolidated it with a new claim which has been commenced properly for the first time in the CAT and to which we don't have a defence. But in my submission, it is telling that they did not do that. What they did was transfer an existing claim. I'm, of course, in some difficulty in speculating as to what it is the claimants thought they were doing, really. It is a matter for them why they took the view that it was appropriate to transfer the existing claim in the High Court rather than start new proceedings in the CAT.
We think it may not matter, but it's probably because they didn't want to pay the costs of discontinuance, whatever they were, which may not have been all that much, I suppose.
Well,
Okay.
In my submission, your lordship's, what your lordship puts to me that it may not matter depends on a construction of the CAT rules that has the effect of defeating the accrued limitation rights that my clients had in respect of the High Court claim. And that is, in my submission, one that applying the principles in Merrick's should not be adopted unless it's unavoidable, and it very clearly isn't unavoidable because a natural and ordinary meaning of the word claim, of the word making a claim, would ordinarily mean commencing proceedings before the CAT. I'm going to turn to look at how the tribunal dealt with the question of construction in its judgment, and I anticipate we can take this relatively quickly because it's essentially largely what's been canvassed already. Core bundle tab 17. Starting at paragraph 41, which is on page 219. And there's the heading, the tribunal's decision. The tribunal is quite right to say that this is an issue which turns on the correct interpretation of the concept of making a claim. Paragraph 42, the tribunal starts with Rule 30 because it says that prescribes the steps needed to be taken in order to make a claim. And it makes the point over the page, final sentence, the natural corollary of the description in Rule 30 of the steps to be taken in order to make a claim is that if those steps are taken, a claim will be made. For the purposes of the rules, the court has my submission as to what we say the error the tribunal made is. We say it's not actually asking itself by make a claim. And had it done so, it would have recognised that a claim had been commenced in the High Court and then transferred to the CAT and couldn't be made again. We say that it has erred in focusing on the procedural steps which are identified as necessary to make a claim, and to say those steps have been taken, therefore a claim has been made. We do make the submission that Rule 30 is not a definitional provision. It is not, in our submission, saying that the concept of making a claim must be understood under the CAT rules as defined by the process of taking these procedural steps. These are the steps that are procedurally necessary in order to make a claim, but they do not define what is meant by making a claim. Subparagraph 43. The tribunal says that in order to succeed in showing that the claim is time barred, the defendant would have to establish that the references in Rules 31 and 119 to the making of a claim are to be read restrictively, so as to exclude the finding of a claim form done as the continuation of the proceedings transferred from the High Court. We say in our submission that that is putting things backwards. We are not advancing a restrictive interpretation. We are in our submission relying on a natural and obvious meaning of the words making a claim. And we are relying on the meaning of those words as read in the context of the rules as a whole. And we say that the construction the tribunal has adopted is an inappropriately expansive reading of the word make that incorporates both the commencement of a claim and also the remaking of a claim that has been transferred. But that is what the tribunal means when it refers to adopting a restrictive construction in terms of the following paragraphs of the judgment. We do say, however, that the tribunal is right to find in the last sentence of 43 that the claim form was filed as the continuation of proceedings transferred from the High Court. And the reason I flag up that point is because the claimants have made the point in their skeleton, paragraph 25.3, they say it would remain possible to analyse the filing of the CAT claim form as having commenced the fresh set of CAT proceedings asserting the claim in parallel with the transferred proceedings. And we say not only was that clearly not what was actually going on, but it was not what the tribunal found to have been going on. And there's been no respondent's notice in relation to the tribunal's finding that this was the continuation of proceedings transferred from the High Court.
Why can't it be both? Why can't it be both the continuation of proceedings transferred and a fresh claim in the...
In my submission, it cannot be both an existing claim and a new claim. It must be one or the other.
Why? It's the existing claim as was in the High Court, but it's a new claim in the CAT.
Because the concept we're seeking to construe, making a claim, in my submission means commencing proceedings. And it can only be, proceedings can't be commenced
The
twice.
rules are talking to, if the rules are talking about a claim in the CAT, then it can be continuation of a transfer claim from the High Court, but making a new claim in the CAT. Why not?
In my submission, that is not consistent with the ordinary understanding of the word making a claim, which means to commence proceedings. One doesn't, in any ordinary sense, when one says making a claim, it means the point at which those proceedings are originated for the first time.
That takes us back to the same issue. As
It
to
does.
What does issuing a claim form do?
That is absolutely the core of this.
And you're making a claim in the CAT, well, you haven't previously made a claim in the CAT.
Well, but you have made a claim in the High
So,
Court and you're transferring it
It
across.
goes back to the point my lord put to you earlier, which is that what the history may be irrelevant. And that's the issue. It's a very narrow issue, really.
I don't disagree that it's a very narrow issue. I do say, however, that if there is already an extant claim, on a true reading of making a claim, it doesn't encompass transferring across an already existing claim.
Okay.
Paragraph 44 recognises that the headings to Rule 30 provide some support for what the tribunal has described as a restrictive construction.
Yeah.
And similarly, in 46, the tribunal is prepared to afford some limited weight to the instances of references to commencement of proceedings and the headings and the body of Rule 119. We say it's not clear why that weight should be only limited. We say it's very clear what the rules mean in that context. The tribunal then says, it does not in our view follow that commencement is to be read in an exclusionary sense, so as to deprive the filing of a claim form in proceedings that have previously been transferred from the High Court of the significance which this step would otherwise have for the purposes of the tribunal rules. No cogent reason was put forward by the defendants as to why the filing of a claim form in transferred proceedings should be treated differently from the filing of a claim form unconnected to the transfer. Again, we take issue with the suggestion that commencement is being read in an exclusionary sense in that way. We say the real question is why one would take an improbably expansive view of the meaning of those words to incorporate something which wouldn't normally be understood as being within the word, the commencement of a claim. And the court has my submission as to why the filing of a claim form in transfer proceedings should be treated differently. We do say that there's an absolutely fundamental distinction between simply serving to particularise an existing claim and originating a new claim. And of course, in some transferred proceedings, it won't even be necessary to file a claim form in the CAT because the particulars have already been filed in the High Court. And we do say that that means that on the tribunal's construction, this exercise of filing a claim form assumes disproportionately heavy significance, and it has the potential for arbitrary outcomes. Final sentence of 46 says the filing of the claim form in proceedings transferred from the High Court is the commencement of proceedings in the tribunal. It's the necessary first step in a different jurisdiction sufficient to set in train a process in that jurisdiction that leads to a decision establishing a legal liability. In our submission, that reasoning is wrong for two reasons. We say it's not right to suggest that the filing of a claim form is a necessary first step for transfer proceedings in the CAT. It was a pragmatic solution agreed by these parties in the circumstances of this case to avoid the need to file particulars of claim in the Chancery Division, but the parties could equally have agreed that the particulars of claim be filed in the Chancery Division and then stand as a pleaded case in the CAT.
I don't think they could, only if the CAT agreed.
Yeah.
The parties can't compel the CAT, so if the CAT agrees with that, then it's a CAT order that the particulars of claim equal the claim form.
It must be right that the CAT could say, I'm not satisfied as a matter of my rules, that you have effectively satisfied the rules. That doesn't, in my submission, mean that the CAT is there saying, I want you to originate a new claim.
Well, then the question is, as you put it, depends how you classify the CAT order saying the particulars of claim shall now stand as the claim form, and that order then triggers satisfaction with rules.
It does, and it's of course within the CAT's discretion to permit that. But in my submission, it still would not be right unless the CAT were very specific that it considered that what it was directing was a new claim to be filed. It would not be right to equate a direction that particulars stand as a claim form as being essentially a new claim being started in the CAT.
Do you accept that the analysis of that situation would be exactly the same analysis of the situation that we face in this case, namely either the CAT directs that the particulars constitute the claim or the new claim is issued, you would still say in either case, they're still, because they're subject to a transfer, proceedings were still commenced in the High Court.
Absolutely, I would make that submission, because essentially the CAT will be saying, I am directing that these particulars of claim satisfy the requirements of Rule 30. Rule 30 is setting out procedural requirements, but it's not, in my submission, defining the concept of making a claim, and the claim has already been made in the High Court.
So if you're right on one, you're right on the other, but equally if you're wrong on one, you're wrong on the other.
I think that must be right.
I think that must be right, because if you're wrong about what's meant by making a claim, the argument against you, which is that the Rule 30 requires the filing of a claim form to make a claim in the CAT at all, then if the CAT says, well, the particulars of the claim will stand as a claim form, then that's making a claim on that analysis.
Yes,
So,
I think I accept that either I'm right on both or I'm wrong on both. I do say, though, it is relevant to bear in mind that all that's happening here is a change of venue. And so if these were proceedings that were being transferred from Manchester to London, or proceedings being transferred from the King's Bench Division to the Chancery Division, or in the other direction, there will be no sensible suggestion that the effect of transferring the venue in that way would have the effect of making a new claim. It would simply be moving the venue for the claim to be determined.
Two entirely different sets of rules here. We've got the CPR governing one, and we've got the tribunal rules governing the other. Different rules, different court constitution, different prescription.
My lord, that's absolutely right, but it does beg the question, why should the tribunal be different in that respect? Why should the effect of transferring something into the tribunal be equated to making a new claim in circumstances where it would not be in any other venue? There's no, in my submission, principled reason why the tribunal would treat it any differently.
I was wondering that. I think the answer is that Parliament actually created a new set of limitation rules for the CAT, and because of the way in which proceedings could overlap and the different cut-off dates for claims, there was going to be a reasonably long period where you could have proceedings running in both, or where you could be time barred in one and not the other. I mean, Parliament's just accepted that as a consequence. And that is the effect of the rules, and we can see it in a number of cases where we've got different limitation rules running in the High Court and the CAT. But that was Parliament's solution, good or bad.
It is absolutely right that Parliament envisaged that there would be parallel and different limitation provisions in both the High Court and in the CAT. That doesn't necessarily mean, in my submission, that one has to then understand the exercise of transferring a claim from one venue to the other to be any different. One can still take advantage of the different limitation provisions in the High Court and the CAT by commencing proceedings in the ordinary way in the CAT. It doesn't, in my submission, follow that one would necessarily understand making a claim to be different in the tribunal than anywhere else. Paragraphs 47 and 48 are where the tribunal addresses the judgment in Sainsbury's. Again, it accepts that it provides some apparent support for our construction, and it doesn't consider that Sainsbury's was incorrectly decided. That's the last sentence of paragraph 48, where it says we do not consider that Sainsbury's was incorrectly decided, and we agree to that extent. The tribunal suggests that Sainsbury's is distinguishable from the present case, and the distinction that it relies on is in the first section of paragraph 48, where it says Sainsbury's was not concerned with a case such as the present one in which proceedings were transferred and a claim form filed in the tribunal within the Rule 31 period. So in my submission, that really does cast a spotlight on the fact that this turns on a procedural happenstance that a claim form was filed in the tribunal post-transfer. And then it said, insofar as Mr. Justice Barling held that Rule 31 only applies to claims originating in the tribunal, there is no reason to assume that he had such a case in mind. We do not read his judgment as excluding from the category of proceedings originating in the tribunal proceedings in which a claim form has been filed there. So here, the tribunal is saying that the concept of originating proceedings is to be construed broadly to include filing a claim form in the tribunal in transferred proceedings. And we say again, that is not a realistic interpretation of the concept of originating proceedings. just as with making a claim and as with commencing proceedings, so with the concept of originating proceedings, we say they all have an obvious and natural meaning, and that would never normally extend to transferring claims to the tribunal.
I understand, you said earlier, I think you said a number of times that effectively the proceedings in the CAT are the same proceedings or the same claim as it was in the High Court.
It's the transferred claim.
But
Yes.
as I understand it, the claim, the brief particulars of which we have, is a standalone claim which by necessarily made no reference to section 47A because the decision hadn't been made at that point. Now, and then when we come to the claim in the CAT, it starts overview, a claim for damages under section 47A. Now that claim isn't in the High Court claim form, nor on a quick review do I think the standalone claim is in the CAT claim. So it doesn't seem to me it is the same claim, or certainly not identical claim.
The distinction is that by the time they bring the CAT claim, the claimants have the benefit of a finding of infringement that they then seek to rely on, which is what constitutes the follow-on claim. So essentially one of the elements of the claim that they would otherwise have to bring and establish in their own right has been established for them by virtue of a commission decision which has been upheld on appeal. In my submission, that doesn't make it a different claim. It simply means they have a finding of liability in their favour.
Surely the claim under section 47A is the statutory right to bring a follow-on claim following an infringement.
Which has all sorts of consequences in terms of the evidence that's required to prove the claim and so forth.
Well, they can bring a follow-on
The
claim either.
standalone claim would require full proof of absolutely everything.
My lord, yes, they would have to prove liability on a standalone basis, and actually that element of their claim they don't need to prove in their own right because they then rely on a commission decision. But it doesn't, in my submission, make it a different claim. And a follow-on claim or a standalone claim can each be brought either in the High Court or in the.
Absolutely, but if they
the
wanted
CAT.
to bring a follow-on claim in the High Court, leave aside limitation, if they wanted to bring a follow-on claim in the High Court on the basis of the claim form they had already issued, they'd have had to amend it. Because as my lord says, it's a standalone claim, not a follow-on claim. It doesn't make any reference to any decision of any of the competition authorities at all.
Well, they would identify that in relation to that element of their claim, they are now able to rely on a commission decision making findings, and that they duly do rely on it. In my submission, that doesn't materially make it a different claim, and no part of the tribunal's judgment suggested that they were treating this as a different claim that was now being commenced in the CAT. They do specifically say this is the continuation of proceedings transferred from the High Court. So they certainly weren't considering this to be in any way a new or different claim.
No.
My misunderstanding then, my understanding is that section 47A provides the cause of action.
No, my lord, it's a jurisdictional provision. It's in the authorities bundle. The cause of action is a claim for breach of statutory duty and breach of Article 101, and Section 47A is the jurisdictional provision that provides that the CAT can hear such claims, but it's not the cause of action. It should be in
Page 5.
it's tab 19 in the authorities bundle. So 47A is headed monetary claims before the tribunal. Subsection 1 is defining the claims to which the section applies. Any claim for damages or any other claim for a sum of money which a person who has suffered loss or damage as a result of the infringement of a relevant prohibition may make in civil proceedings brought in any part of the United Kingdom. And then subsection 4, a claim to which this section applies may, subject to the provisions of this Act and tribunal rules, be made in proceedings before the tribunal. So the relevant prohibition, the cause of action, are those which are set out in subsection 2, either the domestic competition law provisions, the Chapter 1, Chapter 2 prohibition, or pre-Brexit, the prohibitions in Article 101 and 102. So those are the causes of action.
Subsection 5 provides you can't make a claim under 47A unless and until there's a decision of a relevant competition authority. That the relevant, there's been an infringement of the relevant prohibition. So there's no cause of action
Your Lordship's right,
under
of course.
47A,
That's absolutely right. Of course,
which is
now
why the 2-year limitation period was brought in the CAT, because it was 2 years from the date when the cause of action accrued, and the cause of action accrued when the competition authority, the commission or whoever, or the CMA, made its decision that there had been an infringement.
my lord, yes, in relation to a follow-on claim, of course you can now, before the CAT, bring a standalone claim.
Oh, I understand that, but that was all subsequent.
So,
I mean, one of the problems is that, as we said in Merrick's, these provisions are not exactly elusively clear, any of them.
well, that is certainly true. I do pray that in aid, in the sense that I say we are in the Merrick's territory where we are seeking to apply a construction to the CAT rules in circumstances where one construction has the effect of defeating my client's accrued limitation rights. We were looking through the tribunal's reasoning.
Yeah.
Paragraph 49,
Yeah.
page 222. The tribunal makes the point that the party's subjective understanding of what they were doing doesn't affect the legal consequences of filing as regards limitation periods, and they accept the claimant's submission that in the interest of legal certainty, rules on limitation should be construed objectively. To be clear, we don't take issue with that at all. We simply say that the objective construction of the rules referring an already extant time-barred claim doesn't restart the clock. Paragraphs 50 to 51 are the paragraphs where the tribunal addresses our submission that the claimant's construction of Rule 31 could have arbitrary consequences depending on whether particulars of claim have been served in the High Court prior to transfer or not. If they have, then there's no need to serve a claim form in the tribunal and the claim's time barred. If they have not, then one solution is that the claim form is served in lieu of particulars of claim and the claim is not time barred.
The problem is that because these provisions are not really extremely well drafted, whoever's right, you can think of arbitrary consequences that might arise. And I think what's said against you is, well, if you turn it around, then you can have arbitrary consequences. If you're right, you might be said the facts of this case give you an example of that. Well, you could have abandoned the High Court and issued a claim in the CAT, but because you didn't do that, you're time barred.
My lord, that's absolutely the point that the tribunal makes in paragraph 50.
Yeah.
Yeah, and they say it will be arbitrary and anomalous if the defendant
But
submitted.
Merrick's is or gives you you can imagine a situation where a claim that would not be time barred under the 6-year rule in the Limitation Act would be time barred because it's commenced in the CAT more than 2 years after the competition decision.
My lord, yes, and that is
Sainsbury's.
precisely the concern that was in Sainsbury's.
Which you might say, well, that's a pretty arbitrary result, but I mean that's the effect of the rules.
I do make the submission that it's an arbitrary result. I do, however, make the submission that it's not a necessary effect of the rules, because if one understands claim to mean commencing proceedings, then that doesn't arise. And in response to what the tribunal says about our position being arbitrary and anomalous, in my submission, limitation defences are always going to be open to that sort of criticism. So it can always be said, for example, that a claim which is issued on a particular day is in time. The very same claim, identical claim issued the following day, is out of time. One might say that that is capable of being anomalous, but limitation defences require bright lines to be drawn.
Yeah.
And our submission is that there is a relevant distinction, a substantive distinction between transferring a claim and bringing a claim. paragraph 51 is the paragraph where the tribunal addresses our argument that this could potentially operate to the detriment of claimants, as it did in Sainsbury's, or as it could have done in Sainsbury's. We do emphasise that that is not an improbable scenario. We know from this court's judgment in Gemalto that time can start running from the publication of a commission press release publicising a statement of objections, and then a claim can be issued in the High Court within, say, 5 years and 11 months of that commission press release, but over 2 years after the relevant commission decision. And so that is a claim which would be in time in the High Court under the Limitation Act 1980 and the principles in Gemalto. But if the cause of action accrued before the 1st of October 2015, for the purposes of Rule 119.3 of the CAT rules, the transitional provisions apply. If we assume there's no appeal to the Court of Justice, and so the Commission decision has become final, that is a claim which would be out of time under the 2-year provisions in the CAT rules. And so if that claim is transferred to the CAT shortly after issue in the High Court and prior to the service of particulars of claim, then the effect is that the Rule 31 time limit applies, and the consequence of transferring that claim to the tribunal will be that the claim that was originally in time becomes out of time at the point when it's transferred to the CAT.
So what the courts do is to find a solution which prevents the extinction of an otherwise valid claim. It's valid in one or other, and the court makes sure that the claim which is within time survives. But on your analysis, the court is required to ensure that a claim which is potentially in time is extinguished in both jurisdictions. We've never had a case like that, have we?
What your lordship is putting to me is that the court will be bending over to attempt to preserve an in-time claim, but my clients have accrued limitation rights in respect of the High Court claim, which is out of time. This is not a scenario when one in
Understood,
isolation
but it's
has
still-
a valid.
Well, you say
in-time
you had
claim.
accrued limitation rights, you had contingent limitation rights. If the claim was continued in the High Court, you'd have been able to rely on the defence on limitation. If they discontinued, you'd have been absolutely, that would have been neither here nor there.
Had they done that,
I
we
know.
accept that that is the situation. And there were options open to them. I do rely on this. There were options open to these claimants. They weren't in a position where there was nothing they could do. What they did do is transfer an extant claim in respect of which we had accrued limitation rights. And we do say that is absolutely fundamentally different than starting a new claim in the CAT.
Can you just explain what you mean by accrued? What does it mean in this context? My lord says it's contingent at this point. It's a defence which is available to you. And we know with the benefit of hindsight it would have prevailed because the claimants accept that their claim was out of time. So it's just a defence which would have been available to you had the proceedings continued. In this circumstance.
In the context of limitation, I think that, in my submission, means that one must examine what is the substantive position as at the time of the transfer, because the purpose of that wording in paragraph 9(1) and 2 of the transfer order is seeking to preserve the substantive position of both parties, the claimants on the one hand and the defendants on the other, at the point of the transfer. And so in that sense, accrued must mean something.
Your right is inchoate and putative at this point. Mostly accrued rights, for example, you've got a property right, you've got a right which someone is encroaching upon, you've got an Article 1 right. But here all you have is one of many defences which might be available to you.
Well, in my submission, it's not inchoate at that point in time. It's true that it has yet to be adjudicated on by the court, but it is, as we now know, the claim was out of time, and therefore I would not accept that it was an
Established in
inchoate.
law. It's conceded. It's not established in law. It may make no difference, but accrued generally is a right established in law. It's an existing extant right, whereas this is, if you like, a jolly good and almost bound to win right, which has yet to be established.
Well, it has yet to be adjudicated on. In my submission, one wouldn't say it would render the concept of accrual fairly meaningless if those rights had to have been adjudicated on, because of course the court hasn't adjudicated on any of the rights that both parties were seeking to preserve. So it can't be simply that it's saying you have to get a court determination in your favour in order for this right to have any value.
It may be you don't need to use the word accrued. You simply say we had a right which it is now conceded was a valid right, which we lose if the tribunal rules are construed as the claimants say they ought to be.
Yes. It may be that accrued doesn't particularly assist in the particular context of limitation rights, because of course limitation bites at the point at where you bring the claim, when you initiate the claim, and so they are our rights, such as they are already established to that extent. Whereas there may be other procedural rights, because of course this was very broad wording seeking to preserve the party's substantive position generally. It may be that there are other rights that materially accrue at different points in time. And of course, if this were a rolling limitation period, 6-year rolling limitation in relation to an ongoing breach, it would be relevant to look at what had accrued at a particular time, because matters that might be out of time at one point may not be out of time at a different point. I'm not sure that that's actually necessarily a good example in the context of limitation, because again one would say it crystallises at the point you bring the
this one
claim.
might be said to be an A40 or A case because the whole lot was time barred on this.
Certainly, our submission is that that is the position.
Situation at all.
I was just going to show the court how the tribunal grappled with the point we make that this does have anomalous results in relation to claimants. And what it says in paragraph 51 is it describes our position as misconceived. And the final line, if no claim form is filed in the tribunal, rules 119 and 31 would not apply. The relevant limitation period would continue to be the Limitation Act 1980 period in accordance with the decision in Sainsbury's. That, in my submission, is strikingly failing to address the counter scenario, which is what happens when a claim form is filed in the tribunal, in which case on the tribunal's construction of the rules, the claim does become time barred. We say what it really highlights is that this approach of focusing on the claim form, the procedural happenstance of whether a claim form is or is not filed post-transfer, is highly unsatisfactory as a matter of construction of the rules and as a matter of common sense. And we do say it's equally unsatisfactory in the particular circumstances of this case, because the fact that these defendants agreed, acting pragmatically and constructively, to the claimant's proposal to file a claim form in the CAT rather than particulars of claim in the High Court, all the while going out of their way expressly to reserve their limitation rights and preserve their position, suddenly becomes of decisive significance, despite the fact that both parties have agreed on the face of the transfer order that the fact of the transfer was not intended to alter the substantive position in respect of limitation. We say that is a highly unsatisfactory distinction.
You say it's a procedural happenstance. Could there ever be a case in the CAT where no claim form was filed, or the CAT exercises its discretion to direct that some other documents stand as a claim form? Wouldn't there have to be one or other for the proceedings to be validly constituted in the CAT?
I am not sure whether it is the case that every claim that's been transferred from the High Court to the CAT would have been accompanied by a direction from the CAT to the effect that it is happy that the particulars of claim will stand as the claim form in the CAT. I cannot claim to have done a survey.
There have to be some sort of order, wouldn't there? I mean, if you look at the example we've debated about if they insert particulars of claim in the High Court, and they would then have gone to the CAT and said, leaving aside the limitation issues, said to the CAT, look, we shouldn't have to serve a claim form in accordance with Rule 30 because we've already served these detailed particulars of claim. And then the CAT would surely at that point make an order that they were to stand as a claim form.
Well, that only
Because
becomes...
otherwise the proceedings aren't in the CAT at all. There's nothing that incepts the proceedings in the CAT.
Well, the inception of the proceedings in the CAT is the transfer under section 16(4) of the Enterprise Act. So it's not, in my submission, a situation where one needs a direction of the CAT to confirm receipt essentially, and
Well,
to
that's right, because I think the CAT would always have a discretion about what claims is accepted on transfer. wouldn't it?
Yeah. And it can also waive, I think there's a, I can't remember which provision, which says that irregularities in proceedings do not render the provisions void.
it can, it absolutely can.
But
The
it
question
would
is
have
whether
to
it's
do something.
necessary. Whether it's necessary for it to do anything at all. In my submission, if there's a fully constituted extant claim in the High Court, assume it gets transferred a year in and it's further progressed, the claim form's been issued, it's been particularised,
Yep.
further procedural steps have been taken. There's no suggestion in my submission that it's a necessary element of any transfer that the CAT has to say, well, I'm formally confirming that I'm satisfied that this is a properly constituted claim. It simply accepts an extant claim that has come to it from another venue.
Well, in practice, as a matter of practical reality, that must be right. The CAT would be unlikely to turn around and say, well, I'm not prepared to accept the claim. But I think that technically, the CAT would still have to, it still has to accept the claim in some way before it's actually in the CAT. Because an order from the Chancery Division transferring the case to the CAT doesn't mean that it's automatically transferred. It just, any more than it would be if it was being transferred between divisions. It requires the consent of both before it's effective.
I certainly see the force of that, but in my submission that doesn't necessarily mean that the CAT has to, in doing so, say, I am prepared to treat the particulars of claim as a claim form. And in my submission, the only reason one even gets into wondering whether the CAT would or wouldn't do that is if one assumes that the claim form is doing something more than what has already been achieved by the particulars of claim in particularising them, particularising the claim.
Can I just understand, going back to Rule 30, which refers to a claim under Section 47A of the 1998 Act shall be made by filing a claim form. Do you accept that a claim has been made under Section 47A of 1998?
No, we accept that when we looked at 119.3, there was a provision which said it falls essentially within this provision if it's under Section 47A. We accept that the claim is one that the tribunal can exercise jurisdiction over because we've seen those provisions which say it's a claim for damages under these infringement provisions, and so it's one over which the tribunal can exercise jurisdiction. But I do say that when the provisions refer to making a claim, they mean originating those proceedings in the tribunal. And these proceedings were not originated in the tribunal, they originated in the High Court. And so they are capable of being transferred, and so they can fall under Section 47A. There's no jurisdictional bar to the CAT hearing.
So has the claimant made a claim under Section 47A?
In our submission, no, it hasn't. The claim was made in the High Court, and that's the way Mr.
So it
Justice...
wasn't entitled to serve a claim form making a 47A claim.
It can make a new claim, but it didn't.
So it's not just, it's a limitation period. It's not just limitation. You're saying they haven't made the claim.
We say that the claim that they have made is the one that was in the High Court. If we go back to the relevant rules behind tab 23, page 569, subparagraph 3 of Rule 119 refers to a claim falling within this paragraph. And it falls within this paragraph if it is a claim to which Section 47A of the 1998 Act applies, and the claim arose before 1st of October 2015. We accept that this is a claim to which Section 47A of the 1998 Act applies. However, the wording of then 119.2 concerns a claim if it were to be made in proceedings under Section 47A. That is different wording, and it is materially different in my submission. It's not just that Section 47A applies, it is that the claim is made. In this case, the claim was made in the High Court.
So when in the claim form it says this is a follow-on claim for damages pursued as a breach of statutory duty under 47A caused by the is identified in commission decision, that has no effect at all.
That is essentially satisfying subparagraph 3 of Rule 119. It is a claim to which Section 47A of the 1998 Act applies.
You're saying it's a nullity.
No, I'm not making that submission. I'm saying that there is a valid, albeit out-of-time claim in the High Court which was transferred. I'm
But
absolutely...
There's no claim in the High Court for under Section 47A. There couldn't have been.
This is too early.
My lord, there was a claim...
The only place that a claim for Section 47A follow-on claim could be seen in these proceedings collectively is through the claim form in the CAT. It's not to be found anywhere else.
Well, it can be seen if a claim which satisfies the requirements of Section 47A is transferred into the CAT. I'm absolutely not suggesting that this claim is a nullity. That is not my submission.
Well, where is it then? Where do we find it?
If it's an irregularity, why can't the CAT waive it under its inherent jurisdiction to waive irregularities, which explicitly say irregularities do not render proceedings void?
It is not an irregularity. It's a question of whether the time limit provided for in 119.2 applies or doesn't apply. In my submission, it only applies to a claim made in proceedings under Section 47A. That is different than the claim to which Section 47A of the 1998 Act applies, which is what subparagraph 3 refers to. So there is no doubt that this is a claim which the tribunal is capable of hearing and it falls within its jurisdiction under Section 47A. But is it a claim to which the time limits in the tribunal apply? We say no, because it is not made under Section 47A. It was made in the High Court and then transferred in. There's no, in our submission, no irregularity.
And how one could say it was made in the High Court when it doesn't appear in any pleading in the High Court. There was no amendment. There was no amendment to the High Court proceedings to include a claim under 47A.
No, well, there'll be
and
no...
what was transferred to the CAT did not include a claim under 47A.
Section 47A is the jurisdictional provision, and so there was no... It's simply the provision that permits the tribunal to hear the claims. There would be no sense in pleading Section 47A in the High Court. It would make no sense at all. It's simply the provision that enables the tribunal to hear this claim. And it bites.
Going back to Rule 30, why isn't it quite straightforward from what you just said that the claim give me a claim under Section 47A shall be made by filing the claim form, and we know that the reference to a claim there means a claim in the CAT.
Well, it means, yes, that Section 47A is the jurisdictional provision which permits the CAT to hear those claims. But this is entirely consistent in my submission with the same distinction that's made in Rule 119. 119.2 refers to a claim made in proceedings under Section 47A, and 119.3 refers to a claim to which Section 47A of the 1998 Act applies. There is a relevant distinction there.
Well, either the claim form made a claim under Section 47A, in which case it falls directly within 31, or it didn't, in which case your submission is there simply isn't a claim.
There are two ways in which a claim can be within Section 47A. One would be if the claim is made under Section 47A in the context of the CAT itself, and the other would be if a claim which falls within Section 47A is transferred in from the High Court. Either of those is a legitimate way of pursuing a claim in the context of Section 47A, but only the first of those involves making a claim, and only the first of those involves the application of the time limit in the CAT rules, in my submission. I'm turning to address briefly the two respondents' notice points that the claimants make. The first is that they advance an alternative potential construction of the 2015 rules, and it may be that this informs to some extent the debate that I've just been having with the court. They say that in the alternative to the tribunal's construction, the claim is made from the point when proceedings were transferred to the CAT, and that, as we understand it, is relying on the fact that Section 47A is the jurisdictional provision that permits claims to be brought before the tribunal. And so they say a claim is continuously being made on that basis from that point. That is an argument that was aired before the tribunal and it didn't find favour. I can show the court where it's recorded as having been made. It's paragraph 40, subparagraph 5 on page 219, where they record the submission that from the point of transfer the proceedings became a claim that is being made in proceedings under Section 47A. We say that rightly didn't find favour with the tribunal. The claimants have to say that made in this context means something other than commenced, and so what they say is that made means in that context some sort of ongoing process of pursuing your claim other than actually commencing it, and they say that ongoing process occurs when the claim is transferred to the tribunal and then takes place under Section 47A in the way that we've been canvassing. We say that's an incorrect construction for all the reasons I've already canvassed, in the sense of the concept of making a claim meaning commencing a claim. But we do say that the rules are very clear that made is not some sort of ongoing process of litigating a claim to its conclusion. And so Rule 31, which we've been looking at, says that the claim should be made by finding a claim form. That is an act which happens at a distinct point in time. It can't be an ongoing process. And similarly, Rule 31, which we've looked at, a claim for damages must be made within a period of 2 years beginning on the relevant date. If the claimant's construction were right, and the concept of making a claim essentially encompasses this ongoing process, pursuing a claim before the tribunal, then this provision would suggest that the claim needs to be not only commenced during the 2-year period, but concluded within that period as well. And we say that that's a construction which is particularly odd in the context of a rule which is concerned with limitation, because limitation does focus on the point in time in which the claim is commenced and not an ongoing process. The alternative construction is in many respects even more extreme than that advanced by the tribunal. They accept that the alternative construction is irreconcilable with the judgment in Sainsbury's, in circumstances where the tribunal considered Sainsbury's to be rightly decided. And it also has what we say is a perverse consequence that time limits in the CAT rules would apply automatically on transfer to the CAT, not just if a claim form is lodged in the CAT. And that would mean that there are an entire category of claims that would simply never be transferred to the CAT because they would automatically become time barred. There isn't the intercession of this process of issuing a claim form which can rectify it. The claimants don't dispute that that's the consequence of their construction. They say at paragraph 33 of their skeleton that the solution is for any claimant for whom transfer will render an in-time claim time barred, the solution is not to instigate or resist transfer. We say that's really not a solution at all, because it means that the desire of the legislature to facilitate the transfer of claims from the High Court to a specialist tribunal will be frustrated in respect of an entire category of claims which were brought properly and in time in the High Court, but would be out of time in the CAT, and we say that can't have been the legislature's intention. There's also a question about what happens in respect of transfers of claims commenced in the CAT in order to benefit from the Rule 31 limitation period, which are then transferred out to the High Court. And we've cited the Deutsche Bahn case as an example of that happening. On the basis of the claimant's construction, those claims would cease to be claims made in the CAT in the sense of that ongoing process of seeking relief before the CAT. And so the Rule 31 limitation period would, on their construction, no longer bite. The Limitation Act 1980 would take effect, and the claim commenced in the CAT could then become time barred when being transferred back across to the High Court. The claimant's answer to this problem is in their skeleton at paragraph 35.4, and they say there a claim commenced in the CAT would continue to be a claim that had been made in the CAT, notwithstanding any later transfer to the High Court. But we say it's very much the position that we've been advocating throughout this case. It's a claim made in the venue in which the claim is originated. finally, we simply point out that this novel construction is at odds with what has become established practice in relation to claims transferred from the High Court. They have consistently proceeded on the basis that the Limitation Act 1980 continues to apply to claims transferred from the High Court, and we've cited the Allianz case as an example of that. We accept that, of course, it's not a complete answer, but it does indicate that the tribunal would have been proceeding on a flawed basis in a considerable number of cases, not just in Sainsbury's. The second respondent's notice point is concerned with the position of the 12th defendant, Sun Pharma, and the submission that's made in respect of that is that because the claim was first commenced by means of the amended claim form in the CAT after the transfer to the CAT in respect of Sun Pharma, they say it can't be time barred in relation to the 12th defendant, even if it's time barred in relation to all the others. We say, in a nutshell, that the 12th defendant was added as a defendant to the existing proceedings which had been transferred from the High Court to the CAT. So if we are right that those proceedings remain governed by the Limitation Act 1980, then the 12th defendant has essentially been added to proceedings which are already out of time. So we say whether the claim is time barred as against the 12th defendant turns on the same question as for the other defendants, namely whether limitation in the proceedings to which it has already been added is governed by the Limitation Act or the CAT rules.
Yeah.
I've shown the court the correspondence that relates to that point. The tribunal did make factual findings in its judgment at paragraph 28, which is pages 213 to 214. This is where it sets out its findings in respect to what happened. And the relevant passage we rely on is right at the end of this paragraph, where they say the reference to these proceedings must have been to the transferred proceedings as they were prior to the filing of the claim form in the tribunal.
Yeah.
We've mentioned in our skeleton the doctrine of relation back under section 35 of the Limitation Act. That's obviously the principle where a claim brought against a new party is deemed to have been commenced as at the date of the original action. The addition of a new party is often opposed on that basis because the consequence of the relation back doctrine might be to prejudice a limitation defence. What it underlines in our submission is that the limitation position of that new party that's being added to the proceedings will be the same as the limitation position in the underlying claim. So our submission is the position of the 12th defendant stands or falls with the position in the original proceedings. I'm turning, and I hope I can get through this by lunchtime, to deal with our second ground of appeal, which concerns contractual estoppel. As the court will appreciate, this only arises if we are wrong on ground one, and that would be either because the tribunal was right to find that by finding a claim form instead of a particulars of claim, the claimants have made a claim for the purposes of Rules 31, 119, or alternatively, because the claimants succeed on their respondent's notice point, and the claimants were making a claim under section 47A on an ongoing basis from the point when they pursued their claim before the tribunal. In those circumstances, we say that the parties clearly and unequivocally agreed that the transfer would not undermine the defendant's accrued limitation rights, and we say that the claimants are stopped in these proceedings from contending otherwise.
That couldn't relate to the 12th defendant.
That doesn't relate to the 12th defendant, we make that concession, yes. The applicable principles governing contractual estoppel are common ground. We take the headline statement of principle from Chitty on Contracts at Authorities Bundle 26.
Yeah, it's the very end of the bundle, isn't it?
I'm sorry, my lord, I didn't hear that.
It's the very end of tab 26. That's the principle.
The relevant paragraph is paragraph 729, where it says this form of estoppel is said to arise when contracting parties have in their contract agreed that a specified state of affairs is to form the basis on which they are contracting or is to be taken for the purposes of the contract to exist. The effect of such contractual estoppel precludes a party to the contract from alleging that the actual facts are inconsistent with the state of affairs so specified in the contract. And we just draw the court's attention also to paragraph 730, second sentence, where it says contractual estoppel does not require a representation or reliance or unconscionability. It's also common grounds that a consent order is capable of giving rise to a contractual estoppel, and there's an example of that in the bundle authorities tab 9. This very briefly was an application for summary judgment which was resisted by the defendant on the basis that he had never been validly served with the claim form and particulars of claim, and the claimant then argued that the defendant was contractually stopped from making that argument by reason of a consent order. Paragraph 5 within this judgment records the claimant's argument that the effect of the consent order, which of course was an agreement between the parties, was that this operated as an estoppel so as to debar the defendant from now taking any point on service. And he was satisfied that as a matter of law that argument could be made. And then it's an argument which was accepted in paragraph 6, where the judge was essentially making the point that there was no point in providing for a defence and counterclaim unless the parties had agreed to proceed as if the particulars of claim had been served, and nor would the parties have provided for the transfer of proceedings from the QBD to the mercantile court. And so his finding is that this was the clearest possible foundation for the estoppel claim for by the claimant. That's just essentially an example of a consent order operating in the way we contend for as a contractual estoppel.
I don't think many people in this room will remember, one or two might, but I seem to remember under the Restricted Trade Practices Act, court orders could be registrable as restrictive agreements if they were consent orders. And the name Topless and Guessy comes into mind. Probably before you were born.
I'm happy to agree with that. It must conceivably be possible in the sense that the consent order is an agreement, and conceivably the agreement could contravene the relevant provisions.
Yeah.
In this case, we say
Jesse says it's not really it's not really a species of estoppel at all. It's really just a question of construing the relevant contract.
it does, yes, because you don't have to show
Consent order
reliance.
is an agreement or a contract, and the issue is what's the correct construction. In a sense, we've already got your submission on that.
Your Lordship's right. Our submission.
I mean, if you're right about 9.1 and 9.2, specifically 9.2, then you say this is an attempt by the claimants to go behind what they've agreed.
We make that submission in relation to 9.2. We also rely on paragraphs 6 and 7 of the transfer order, because we say that was an agreement as to the legal effect of the claim form as being essentially serving instead of particulars of claim and not initiating a new claim. And we say that the effect of both of those agreements is that the claimants are stopped from making assertions to the contrary. To show the court very quickly what the tribunal said in relation to this, call bundle tab 17. Starting at page 223. They've summarised the applicable principles at paragraph 53, and they record that they were not in dispute. Paragraphs 54 and 55 summarise the parties' respective submissions. Paragraph 56.
Was there a decision?
We say is asking the correct question, which is whether the case now advanced by the claimants is inconsistent with the parties' agreement contained in the transfer order. Paragraph 57, the final sentence in our submission, rightly recognises that the defendants had an accrued right. They say the accrued right the defendants had in relation to limitation was a right to defeat the existing claim as constituted in this court, i.e. in the High Court, on the basis that the Limitation Act 1980 limitation period had expired. And we say that what the tribunal is essentially here doing is rejecting an argument that the claimants made, and that appears again at paragraph 39 of their skeleton before this court, that paragraph 9.2 was essentially a statement of the parties' common intent, but it didn't actually have any substantive content. in our submission that is clearly not right, and we say that 9.2 preserves the defendant's rights in the same way as 9.1 preserves the claimant's rights, and we emphasise that the tribunal rightly didn't adopt the construction which said that these provisions essentially had no substantive content whatsoever. And we do point out that no respondent's notice point has been lodged in relation to that. We do make the submission that the arguments that have been advanced by the claimants in these proceedings to the effect that their claim is no longer time barred are wholly inconsistent with the appellant's accrued rights and the parties' agreement to the transfer order that the transfer would not affect those accrued rights. In essence, by reason of the transfer, the defendants have been deprived of their accrued limitation defence, despite the claimants expressly agreeing that the transfer would have no such consequence. The tribunal took the view that there was no inconsistency between the case now advanced by the claimants and the parties' agreement, and it gave two reasons for that. The first is in paragraph 57, where it says it was always open to the claimants to bring a valid claim within the Rule 31 period by filing a claim form with the tribunal, and that the appellants had no accrued right under the transfer order to defeat such a claim. Now we say it's important to note how the tribunal describes that claim that it has in mind. It describes it in paragraph 57 as a prospective claim, and it describes it at paragraph 58 as a future claim. And so the finding is that there is no right to defeat a new, different, putative future claim before the tribunal. And that is not in dispute. But we say that these claimants elected not to bring a new claim, and the tribunal has rightly elsewhere in its judgment accepted that that was not what they did. And that's its judgment, paragraphs 43, 45 and 46. We say that the present claim is not a new, different, future claim. It is the transfer of a claim from the High Court, and it's the transfer of the very same claim that the tribunal has found that the defendants have an accrued right to defeat. It is the transfer of that very claim. The tribunal's second reason is the one that's given in paragraph 59. And there it suggests that there was no inconsistency with the parties' agreement that neither the transfer order nor the transfer itself would interfere with the defendant's accrued rights because, says the tribunal, the claimant's reliance on the Rule 31 period was independent of both the transfer order and the transfer itself. In our submission, that simply doesn't reflect the facts, because the claimant's reliance on Rule 31 is inextricably linked with the transfer order and the fact of the transfer itself. The court has seen that the only reason the claimants filed a claim form in the CAT at all, rather than particulars of claim in the High Court, was because of the terms of the transfer order, which in turn reflected the terms of the parties' agreement on that point. And paragraphs 6 and 7 of the transfer order expressly provided for the filing of the claim form in lieu of particulars of claim. And on the tribunal's reasoning, it is precisely that procedural step that suffices to make a claim and to cause the Rule 31 period to apply. So we say the claimant's reliance on Rule 31 in this way isn't some separate analytical question that can be disaggregated from the parties' agreement as to the transfer. It is a direct consequence of, and we say it's inseparably connected to, the act of transfer and the terms on which the parties had reached agreement that that transfer should take place. We say...
Can I ask you a question? You say, and I don't think it's disputed, that parties can agree to something which they know not to be true.
Yes.
If that is the case, for a court to ask why the claimants would agree to run headlong down a blind alley into a brick wall, why would they agree that?
Well, in a way, what the claimant's subjective state of mind was is one for the claimants rather than us. One can speculate that they didn't realise that that was...
And did you know that they didn't realise?
I don't have any instructions on what our speculation might have been.
Very unattractive if your contention is that your clients entered into this agreement to preserve limitation rights, knowing and intending that if this went ahead, you would then say, ha-ha, you can't bring your follow-on claim because your statute barred.
Well, my lord, that's a little bit unfair on my clients in my submission.
because
They are
the fact
entitled to preserve their position in respect of the High Court claim. What they absolutely didn't do is in any way seek to prevent the claimants from bringing a new claim in the CAT.
It sounds
That
like
was
you
It
really-
always...
all
sounds like you-
turns on what's meant by accrued limitation rights as opposed to, because if you're wrong as to what's meant by accrued limitation rights, then none of this arises, does it? Because on that hypothesis, whatever it was that they did in the CAT didn't affect the accrued limitation rights you had in the High Court under the Limitation Act. So they were just irrelevant.
Well, that is what the tribunal has said. Essentially, it's trying to disaggregate the two. But in my submission, that is simply unrealistic, given the way in which... And here, in my submission, one does look at the history, albeit from an objective perspective, because, of course, it's an objective construction of the contract. It's not, in my submission, in any way realistic to suggest that what happened in the CAT can be somehow divorced from the fact of the parties' agreement that this matter will be transferred and their express agreement as to the procedural steps that would need to be taken and the effect of those procedural steps. It's, in no way is it divorced. And in my submission, there is nothing in any way unfair or unattractive about both parties agreeing an even-handed provision in paragraph 9 of the transfer order, which on the one hand preserved the claimant's position as it stood as at the time of transfer, and on the other hand preserved the defendant's position as it was at the time of transfer.
But what is absolutely plain from the correspondence you showed us was the claimant made absolutely clear their intention that they would bring a follow-on claim by this route. And if you're right, your clients agreed those terms as to transfer with the claimant, knowing that they were making a terrible mistake and would not in fact be able to do what they were intending to do.
My lord, no,
Very unattractive.
I strongly resist the suggestion that that was the way it occurred. It's certainly the case that my clients, quite within their rights, sought to preserve their position on limitation, because it cannot be expected.
You had no position. They were perfectly within their right to commence new proceedings in the CAT, which is of course what the primary argument is, that they did that. Your case is that they didn't do that, and you can say, ha, by virtue of this agreement, you may not have realised it, but you're stuck because you went down this procedural route rather than a different procedural route.
My lord,
It's a gotcha.
in my submission, it's not, for perhaps two reasons. The first is that the position on limitation crystallised in the Gemalto case, which was the transfer predated Gemalto, and so at that time it wouldn't have been clear whether we are right or not right on limitation. And the position on limitation further crystallised when these claimants conceded the requisite knowledge to mean that they were out of time in the High Court. We, of course, did not know what the position was. We certainly made clear that we were reserving our right to test that proposition, and we were absolutely within our rights to do that. But it wasn't in any means clear until essentially the point where the Limitation Act 1980 case was conceded by these claimants shortly before the preliminary issue hearing.
It certainly couldn't have been clear to the claimants that they were agreeing by these terms that when they were attempting to commence the Section 47A claim in the CAT by virtue of the transfer, that they would effectively be wasting their time.
My lord,
Because
it may well not have been. It doesn't preclude me from making that submission now, in my submission.
Well, the tribunal, that's the point the tribunal itself makes in paragraph 61, isn't it? That there would be no purpose whatsoever. No conceivable reason why the last sentence, why the claimants would have agreed to give up their prospective right to bring a claim within the Rule 31 period. Nothing in the transfer order suggests that's what was intended.
My lord, yes, and we
That's,
don't take issue with that at all. We have not sought in the transfer order in any way to preclude them from doing that. What we have done perfectly legitimately in our submission is reserve our position as it was before the High Court.
well, your position is that they didn't the effect of what they did was not to make a claim or bring a claim or commence a claim or whatever. And we understand that, it's your ground one, right? But if you're wrong about that, then this doesn't really arise. I don't see how this is going to arise, really. How can you say in those circumstances, if what they're doing is making a claim in the CAT on this hypothesis, which they're entitled to make within the 2-year period, what is there in the transfer order that stops them from doing that? And that's the point, I think.
My lord, yes, and my submission would be that that is essentially treating bringing a new claim as is in some way disaggregated from the process of transferring the existing claim. That is inconsistent with what even the tribunal found, which it said on at least 3 occasions that it accepted that the correct characterisation of what was going on was that it was a transferred claim from the High Court to the CAT. It wasn't treating this as a unrelated new claim which was being brought.
Right.
And in my submission, it's particularly clear on the face of the transfer agreement that everything that essentially was provided for in the transfer agreement is what is now relied on to say we have brought a new claim. And so to suggest that those consequences are somehow divorced from the fact of the transfer and so don't contradict the parties' express agreement on the face of the transfer order, in my submission, is unrealistic.
Your case rests on really the wording of 9.2, the transfer order. Was that primarily where your accrued rights arise?
It's 9.2, plus we also rely on the separate agreement as to the legal effect of the serving of particulars, serving of a claim form in the CAT in paragraph 6 and 7 of the transfer order.
In relation to 9.1 and 2, I'm just looking at the structure of it again. 9.1 says if the CAT doesn't accept any part of the claim, then the claimant reserves its right to continue in the High Court. And 9.2 says none of our rights in the High Court are in any way altered, limited or excluded. Why isn't it a perfectly logical interpretation of 9.2 to say that it arises in circumstances where the claim does remain in the High Court because, for example, the CAT rejects it for some reason, which wasn't apparent at the time. I'm just reading 9.1 and 2 as a whole.
In my submission, that is not the effect of what's going on, because you see the same wording in paragraph 1 and paragraph 2, and the wording is referring to nothing giving effect to the transfer or the transfer itself is intended to alter, limit or exclude either the claimant's rights or the defendant's rights. And the proposition your lordship's putting to me is actually the opposite, which is essentially if the transfer is ineffective in relation to a particular element of the claimant's claim, well then you're effectively reserving your rights. That is not, in my submission, consistent with the opening wording of both paragraphs, and it would also be essentially odious because if an element of the claim remained in the High Court, then the defendant's rights in respect of that element of the claim would be preserved. There would be no reason to think that that would change anything about their accrued rights in the High Court.
I mean, just looking at the second half of 9.1, summarising, if to the extent of any element of the claim is not capable of being transferred to the CAT, it's not subject to this order and remains within the High Court. And then 2, defendants preserve all their rights.
In relation to the claimant's claim as constituted in this court.
In this court, prior to transfer.
Prior to the transfer.
But the exact same provision is made in respect of the claimants. So, beginning of 1, so before the reference to the possibility that there might be a residual element of the claim that can't transfer, is a provision that neither this order giving effect to the transfer nor the transfer itself is intended to alter the claimant's claim as constituted in this court prior to the transfer.
It may just be said the claimants are protecting themselves, and if it turns out that that protection is needed, the defendants are protecting themselves.
Yeah.
Well, in my submission, there is no need for either party to protect themselves in that scenario because there's no reason to suppose that an attempted transfer which didn't work would in any way undermine the substantive position of the parties in relation to that proportion of the claim which remained in the High Court. What's a much more logical and commercially sensible reading of 9(1) and 2 is that both parties are seeking sensibly to ensure that they don't find themselves in a worse position by reason of having sensibly and pragmatically agreed to transfer this claim to the cats. In my submission, it's entirely logical that both parties would want to record that they were not agreeing to something which would leave them worse off. My lords, I'm conscious of the time, but I have perhaps 2 paragraphs to go and I can sit down.
Finish.
We say finally the tribunal has made a further error, paragraph 61 in its judgment, in accepting a submission that was made on behalf of the claimants, that the effect of our proposed construction of paragraph 9(2) would be that the claimants were agreeing to give up the right to bring a claim within the Rule 31 period for which clear wording would be required. We say that that's wrong for 2 reasons. Firstly, paragraph 9(2) of the transfer order isn't purporting to deprive the claimants of any rights. Its function is to preserve the defendant's accrued rights. So, given that it is in that way a counterpart to paragraph 9(1) which preserved the claimant's accrued rights, it cannot be said that it is any way affecting the claimant's rights. Secondly, we say, and this is essentially reiterating a point I've already made, nothing about this transfer order precluded the claimants from bringing a claim within the Rule 31 period if they had wished to do so, and they apparently have elected not to do so. And that in our submission is why they are now in difficulty. But it is not paragraph 9(2) that prevented them from making a new claim. It was their election as to how to proceed. Unless I can see this further, those are my submissions.
No, thank you very much, Ms. Hawke. We'll adjourn till 2.
All rise in favour.